Good afternoon. Calling to order the regular meeting of the Sunshine Ordinance Task Force Compliance and Amendments Committee for Tuesday, October 13th, 2009. Roll call, please.
Member Craven Green.
Here.
Right. Member Craven Green present. Member Chu.
Here.
Member Chu present. Member Johnson.
Here.
Member Johnson present. Member Nee.
Here.
Member Nee present. Member Washburn.
Here.
Member Washburn present. Madam Chair, there is a quorum.
Thank you. I have had a request by Mr. Shoemaker, who is here on item number 7, to have that heard towards the beginning of the agenda because of child care issues. I advised him that I will attempt to do so pending the arrival of the complainant, Ms. O'Flynn. So when Ms. O'Flynn and Mr. Schumacher are here.
Mr. O'Flynn is in the audience.
Oh, okay. And is Mr. O'Flynn representing the issue? Okay. Thank you. Well, I don't see Mr. Shoemaker here, so I asked him to be here towards the beginning of the hearing. When he appears, we will have that matter heard out of order. Thank you. I've had no other requests, so if you could call item number 1, please.
Item number 1 is the approval of September 8, 2009 minutes.
Move to approve.
Second that.
Is there any committee comment about the minutes?
I will have some minor corrections that I will send by email to the administrator.
Is there public comment on the minutes?
Yes. Good afternoon. Peter Warfield, Library Users Association. It seemed to me that there had been a discussion of proposed amendments to the Sunshine Ordinance at item 8, and in light of the fact that the committee, or maybe some members of the committee, graciously invited me to comment on a number of points, and I did, it seems to me that the comment by the member of the public, which was myself, should be included in the descriptions of what's going on. And I don't see any specific comments on this item from me. I see a general mention at the very first paragraph under item 8. Mr. Peter Warfield, a member of the public, was also given the opportunity to comment on the amendments. I don't think that that represents in any way the specifics that were provided, nor would I say that it even satisfies Sunshine in terms of providing a summary of what a member of the public has said. To say that a member of the public was given the opportunity to comment on the amendments is a statement of fact, in this case correct, as far as I'm concerned, but it does not summarize what that member of the public said, either in general or on particular sections. And while I was silent on a number of sections, the body was kind enough to ask pretty much on every issue whether anybody from the public or whether I had some comment, and on some of them I certainly did. So I would appreciate if these minutes were not approved right now, and if there were some effort to provide a summary of what this member of the public said at that time on the amendments. Thanks very much.
Thank you. Is there any additional public comment on the minutes? Seeing none.
I have a question. Regarding the changes to the amendments, are they reflected in our October packet? The changes we discussed in September?
They are not through the chain, no.
Okay. They're reflected in the minutes. Mr. Rustam and I need to get together and figure out a way to track the amendments that this committee approves that then need to be resubmitted or submitted to the full task force so that there's a clear record of what amendments have already been approved by the full task force and what have only been approved by this committee. So hopefully this month we'll be able to do that so that in next month's packet we'll have a more active document that shows what has been approved by this committee subsequent to the full task force vote. Is there a motion to continue this item, or my inclination would be to continue this item to allow Mr. Rustum to revise the minutes to include a summary of the comments that Mr. Warfield made during the item number 8 at the last meeting, so that those can be reflected.
Second.
Without objection, we will continue approval of these minutes to the next meeting. And if Mr. Rustin, if you could please put a short summary of Mr. Warfield's public comments, that would be appreciated. Ma'am, do you have a point of order? Please use the microphone if this is a question about point of order.
Sorry, I don't know the protocols of this committee. I'm Jill Manton from the Arts Commission, and I was hoping that my agenda item could be moved up. I was told it was in room 408, so I was waiting for that room to be unlocked. And I am a single mom, and I have to pick up my son from school around 6 o'clock, and I just wanted to make that request if possible.
Thank you. Given that you probably need to leave by 5:30, and no later than 5:30, would that be accurate?
That would be great.
All right, we will see how the agenda goes, and if necessary, we will try to accommodate you, but we may not need to.
Thank you very much.
All right. Item number 2, please.
Item number 2 is the hearing on the status of the July 28, 2009 order of determination of Sue Cawthon against the Library Commission.
Good afternoon.
Good afternoon. And before you speak, I just have a question. Have we heard from the Library Commission about whether or not they will attend this meeting?
No, ma'am.
Okay. And
I sent them a reminder on Friday.
Thank you. And you received no response?
No response.
Okay. And is there a representative from the Library Commission here? Seeing none, I just wanted to make that clear. Ms. Cawthon, you may proceed. You have
5 minutes.
5 minutes.
Good afternoon. This item was, when this item came before the task force, 3 of you weren't there, so I did take the opportunity I would like to play the DVD again for you. The complaint was denial of public comment. So I'll play the complaint the DVD just as I come up to the podium. Good afternoon. I'm Sue Cawthon. I'm talking about North Beach, but not about design. I think you all know that I head a coalition of groups who are concerned about the present plan, and I've passed around.
Can you hold that until we get to that item? That's a North
We
Beach
talked to
item.
the city attorney, and
This is a North Beach item. Will you hold it until we get to it,
North
please?
Beach item is
Will you hold it until we get to it,
the
please?
North Beach item.
You hold it? Are you not listening to me?
The North
Sit
Beach,
down!
The North
Sit
Beach
down.
item is
Sit
about
down.
design.
Please
This
sit
is not
down.
about
Please sit
design.
down. Please sit down. Please sit down. Thank you.
Okay, that can stop.
I've asked other people to hold their items until the North Beach
Wait.
topic comes up.
Well, that's enough to show you that I was denied an opportunity to speak. The second item was North Beach Library. It was a peer review of the North Beach Library design, but that's not what I wanted to talk about. My idea was to talk about this group I had that's a citywide organization to protect the 8 libraries designed by Appleton and Wolford, and North Beach happens to be one of them. I did say I tried to tell her, I finally got to say it about 3/4 of the page down the transcript that you have in front of you. The North Beach item is about the design. This is not about the design. So the upshot of it was that I could have had an opportunity to speak about library issues for 6 minutes had I had the opportunity at general public comment, but I didn't. I did testify during the second item, but I did not have an opportunity during the first item because the chair silenced me. I guess she just didn't want to hear what I had to say. So the task force did rule 6-0, there were only 6 people there, that there was a violation, and they did also rule that it was willful misconduct because the treatment of me was somewhat out of line, and Chair Nee did write a strong letter to the library asking them to take some kind of action. Now, the library did not come to the task force meeting, they didn't come to the EOTC meeting, and they're not here today. So I have no idea if they have any plans to change their behavior regarding public comment. I have no idea if this has made an impact on them at all, but I think that one of the purposes of a task force is to admonish departments when they behave badly, and I think this was bad behavior. Thank you.
Thank you. Is there anyone here to present facts and evidence in support of the complainant? Seeing none, and there is still no representative from the Library Commission, am I correct? Seeing none, the matter is with the committee. Member 2?
We found them in violation of 67.34. That looks like the definition of Sunshine Task Force. Am I right on that? I'm looking at the amendments, but I don't think it's changed much.
I wasn't at that meeting either. Member 2 and I were 2 of the ones excused. Member Nee?
Sorry, I'm having problems reading this because I forgot my glasses. But if memory serves me correctly, the violation that we found was 67.15.
Yeah, and 67.34 is in page.
Oh, okay, yeah, it's in the order of determination. 67.15A and 67.34.
I believe .34, and other members who were at that meeting can correct me if I'm wrong, but it sounds like that was cited because the task force felt that the level of, or the tone or the actions of the chair of the commission constituted willful failure to follow the Sunshine Ordinance, and that's why 6734 was cited.
Okay. Which part of 1634 are we?
6734?
Yeah, 6734.
It's just one provision. 6734 is the willful failure of any elected official, department head, or other managerial city employee to discharge any duties.
Oh, I'm sorry. I'm looking at the amendments. Sorry.
I thought you might be.
And the numbers changed.
The numbers did change.
So it seems like there's something going on at the library, and it's not good. We've heard a lot about it. I'm concerned about sending anything to the Ethics Commission that is not ironclad. I would feel more comfortable sending everything we've heard about the library together if we're concerned about, multiple aspects of it. Or if we're going to send something to the Ethics Commission, I'd like to send it in a different way than we've ever sent it before, with the hope that we're going to get some action out of it. I don't know if you know our background with the Ethics Commission, but we haven't been getting response like we'd like, and there's an opportunity through our discussions with them to change the kind of response we've been getting, and we've actually had some very fruitful discussions with them. So as we look towards doing something about this, because they're clearly not responding. They're not responding to us. They're not responding to individuals. There's something going on here, but how we structure something and give it to the Ethics Commission is something I don't know.
Member Nee?
I'm not sure why this matter is before the Compliance and Amendments Committee at all, quite frankly. A referral to the Ethics Commission would have to be made by the full task force, and there is no reason that the EOT committee couldn't have sent that up to the full task force for referral. Furthermore, this is not a member concerning documents. This is something where what's happened, and we can't travel back in time and see that it happens right. The only thing I would say is if the task force receives further complaints and finds further willful violation from the Library Commission, then we might have a case to go to the Ethics Commission and say, here, we have a pattern. But just based on this one episode, we could still do it based on the one episode. We have a transcript, we have the video recording, and I think a good case could be made for willful violation right there. I'm not sure it's we could move here to send it back to the full task force with a recommendation for referral to the to ethics or to the Board of Supervisors.
What about the 4 times of just that chance that they've had to come here and defend themselves?
They're not required to do that. The Sunshine Ordinance does not, 67.21E does not require that on public meetings, on public meetings, only on public records.
What? I actually think that the way that the task force has operated is that it requires it for both. That's been our consistent practice and our consistent interpretation of that. I agree that the language is not as full as it should be, and that's one of the amendments that you pointed out. But our consistent interpretation is that we've required departments to appear at meetings, whether or not the issue deals with withholding of public records or failure to comply with open meetings requirements of the ordinance. But it's a different issue. I didn't mean to interrupt. Yes, Member Washburn.
I have a question of Member Chu. You mentioned that that the Library Commission has been a problem in the past. So I'm wondering, prior to this, prior to their not showing up at the meetings regarding this particular matter, are there things in the past that might, be part of a pattern?
Well, I was just looking at the complaints for 2009, and so we're at 4 for the library and Library Commission, which my impression would have been higher than that. I mean, like Rick said, it's probably not. We probably don't have the case as strong as it could be at this point.
Any other comments?
So,
my own view of this is that the order of determination, and all we can do on orders of determination for violations of the public meeting provisions is to say that there was a violation. Unlike the Brown Act, we don't have the authority of a judicial body to invalidate something that happened at a public meeting if there was a open government violation, or open meeting violation, and that's what we've done. The order of determination, which is what we would refer to the Ethics Commission, simply says there was a violation. Now, I guess if that a violation was significant enough or serious enough, there could be grounds for us to refer it to the Ethics Commission for enforcement. But the most that they would do is find an official, again, in willful violation. And I think there's very limited things that they can do even at that point, after finding someone in willful violation, for failure to apply open meetings laws. I think the better course is to work with, or at least try to work with, the library to improve their agendas. That, to me, is the problem here. What we heard at the complaint by Mr. Warfield, subsequent to the complaint by Member Cawthon, was something similar, that he felt he was denied public comment on an item. However, that item was worded much differently than the item before us, the Member Cawthon's item. Member Cawthon's item is peer review of proposed design for the North Beach Branch Library. It's very specific. It indicates peer review for the North Beach Branch. And I think Member Cawthon, or I shouldn't call her Member Cawthon, Ms. Cawthon, was reasonable in wanting to speak in public comment on a different North Beach Library issue. Whereas, I don't know if this is consistent, but the agenda that was put before us in Mr. Warfield's complaint had the title of the agenda item was North Beach Branch. And one of the sub-issues, it said they were going to talk about all of the issues related to the North Beach Branch project. And one of the sub-issues in that item was the peer review project. So they changed their agenda, which is what they should do, to give clear notice to members of the public when they can speak to what. And if there's going to be limited public comment because something is on the agenda, you need to spell it out on the agenda, and it wasn't spelled out here. So to me, the issue is a problem with the agenda that seems to perhaps to have been corrected by the Library Commission. I don't know what they're doing currently, but it certainly was different in the complaint that we had following this one. So, I mean, my sense is I don't think this is appropriate for referral, but I would be willing to entertain, a motion to write a letter to the library expressing our displeasure that they weren't here, to find out what they in fact are doing now, just to verify if they have corrected this, and to encourage them to make their agendas specific so that members of the public know when they can comment about different items, and that if they are going to require members of the public to speak about different branches at certain points in the agenda, their agenda should reflect that, which it doesn't here. So I don't know if that's the best course of action. I'm not sure that will satisfy the complainant here, but that would be my proposal. Member Washburn?
Member Craven, I agree with all of those suggestions and the constructive, I think it's good for us to be constructive and proactive and help policy bodies do the right thing. But I also feel that what happened in this case was really egregious and must have had quite an effect on, it had a large effect on Ms. Coppin, but also, a chilling effect on anybody there. And I'm just wondering, and the fact that they haven't shown up, I don't know what to make of that. It seems disrespectful, but it seems to me that we should, I propose that we go back to the full task force and talk about the possibility of going to the Ethics Commission. Even though the Ethics Commission won't do anything further, I think it's just, it further, reflects at least this member's feeling that what happened was beyond the pale, frankly.
Member Craven, Madam Chair. It seems to me that willful violation does carry a possible penalty of removal from office. And if we really want to be strong with this, I'm not sure the full task force will, but if we really want to be strong with this and firm, we can recommend to the Ethics Commission that step be taken, or that she at least be removed as chair of that commission and allowed to remain on it. But there was, as I judged from the video recording that we were shown, seems to me there was inappropriate temperament on the part of the Library Commission chair, and that not only did she violate sunshine, but she did so in a rather rude fashion, and that's very serious, and we should get ethics to consider that. That's one way to go.
We'll now invite Ms. Cawthon up to respond. Clarification, additional points she would like to take before we take public comment.
Thank you, Chair Craven. I really wish you would do something. I know that ethics is not the best venue for us, even though Mr. Grossman has sued them. But I really think this was beyond the pale. I normally wouldn't even have gone to the trouble of doing this because it's I mean, it's good to do it because I know how other people feel, and it's really tough to file a complaint with the Sunshine Task Force, or probably with anybody. Having done it, though, I did it because I felt it was really out of bounds. It was, as Member Nee said, beyond the pale. The woman truly lost control of her emotions, and it did have a chilling effect on the other people. I didn't bring my colleagues with me, but they did testify at the full task force. There were 3 or 4 of them, including Mr. Warfield, and they said they wanted to testify too, to talk about our other issue that we're involved in, but they said there was this hush in the room, and they didn't feel comfortable going up to testify in general public comment, so that when a chair creates an atmosphere of actually fear and you know, a feeling on the part of the public that they really aren't welcome to make their public comment, I think that should be addressed. And I'm very concerned that the library hasn't come to any of our meetings. I did ask the commission secretary why they didn't come to the task force meeting, and she just said, "Oh, we were busy." You know, so I mean, it does kind of snub their nose at the task force also, and they have had other violations. So I really think that this task force could send a message to them, even if ethics turns it down, that we thought it was an offense that was serious enough to send to ethics, and maybe we should send it should go back to the task force as well. I mean, you know, as I say, there were only 6 people there that day, and it was a 6-0 very clearly. I don't know if you noticed in the video, but toward the end, the city attorney starts to walk up to the chair. And by that time, of course, I had just sat down. But I have no idea what she was going to say, but I think the fact that she got out of her seat and walked up indicated that she felt something was going on that shouldn't go on. So, again, I would just ask that we don't let them off easy. Thank you.
Madam Chair.
I mean, it's for the good of the public.
Thank you. It's now back with the task force for motion and deliberation before public comment. Member Nee?
I just have a quick question for anybody in the room on either side of the wall who can answer, and that is, who appoints members of the Library Commission? Board of Supervisors, the mayor, who appoints commissioners?
Please, Mr. Warfield, could you answer that for us?
The Library Commission is entirely appointed by the mayor.
Okay.
And serves essentially at his pleasure.
Okay.
Thank you. The matter's back with us for motion and deliberation.
I would make a motion to write a letter and CC the mayor about our findings, because since he appointed everyone, as you described.
Is there a second?
I'll second.
Is there a discussion on that motion, or I perhaps feel that there might be a second motion that someone would like to propose? I would like to ask our DCI. I'm not really sure what the procedure is at this point. Under our procedures, we're supposed to have motion and deliberation, then open it up for public comment, then come back to vote. But if there is, I know that if there's a motion pending, you have to have roll call before you can have another motion. So what would you advise us to do in this situation?
In a substitute, somebody could offer a substitute motion before the vote on the original motion is taken.
There is a motion and a second before the commission. If you'd like to amend the motion, you can amend the motion.
Is there a motion to amend or a substitution motion that someone would like to make? Member Washburn?
I believe the motion that's on the table now is very general. Send a letter to the Ethics Commission and CC the mayor's office. And I think it's important to specify what we want the import of that letter to be. So I think I like Member Nee's idea that we...
I'm sorry, hang on. I meant the Library Commission, not the Ethics Commission.
Oh.
So I was going lighter than you would like to go, I think.
Yes, that's
So
much lighter, right.
You might want to do a second.
Would you like to amend a motion or make a substitute motion?
I'd like to make a substitute motion. I move that we might as well keep it in our committee. I don't know about going back to the full task force, but somebody might advise me on this. I recommend that we send a letter to the Ethics Commission, CC it to the mayor and to the Library Commission itself, stating that the Sunshine Ordinance Task Force believes that this willful misconduct was so egregious that the mayor, or that there should be some consideration of possibly removing the chair of the Library Commission from her office.
May I make a pointer that you might wish to incorporate in your motion? I'm not necessarily in support of the motion, but I think the way that the procedures here work is that if we want to refer something to the Ethics Commission, what this committee does is we refer it back to the full task force with a recommendation that the full task force refer it on to the Ethics Commission for the following reasons, and the reasons would be what you stated.
Okay.
So I think that perhaps would be a better motion to achieve your goal.
Right, yeah, I had that question beforehand. I didn't know, but yes. That.
So just to restate, your motion would be then to refer this matter back to the full task force in light of the already made finding a willful violation for a referral to the Ethics Commission for further enforcement in light of the egregious nature of the conduct by the chair of the Library Commission in foreclosing public comment.
Right.
Is there a second?
Second.
I have some deliberation to perhaps add. Things are often more powerful to witness than they are on paper. So is it possible to also CC the video?
Yes. All right, so we have a substitute motion, and that will be the order in which it's voted on. I'd like to open it up for public comment now. Public comment on this matter?
Good evening. My name is Randall Evans, and I'm standing here just to hope that you all realize that once folks from the public come to you with these type of concerns, your response is all we have. See, there's no other route we can take when people arrogantly decide not to respect public comment, when they arrogantly decide to not give up public information that's required by law under the Sunshine Act. So when we get to you all, we hope that you all realize that we have done everything we can from a public side of it. So sometimes, with all due respect, I hear you especially always seem to want to either change your motion or take a lighter course. You must realize that when we come to you, we expect and hope that you would raise the awareness, because as you all know, as our president today says, it's transparency that gets us to where we need to be out here in these communities. And that's what folks are doing. They're not cooperating with simple instructions once they are under the Sunshine Act. And that seems to be very frustrating for us to wait the 10 and 25 days it takes to get to our golden moment here just to hear you all not bear all the weight you can down on them. And that's what I'm asking you. I'm not trying to be disrespectful or tell you your job, but I know that when it gets to you folks, we expect from this side of the palladium that you guys put your full force down on these folks, because that's all we have. Thank you.
Thank you. Additional public comment?
Yes, my name is Ace Washington, and this is my third time coming to this commission, but it won't be the last. I agree with the prior speaker that this is our only avenue. When I say our, I'm speaking of community people. I'm talking about the press. I'm talking about specifically African Americans. When it comes down to issues of public and how we are treated in the public by people that appointed or on chair positions where they could just think they could just tear you down and just have you. And then the first thing they do, in my experience, is somebody must have a button somewhere where they get the sheriffs up here right away. And that's is the repercussion that they have on that side. But as Randall said, on our side, we have none but y'all. So if that's the case, you got to believe that Ace on the case will be monitoring y'all to make sure that y'all, because if you don't have enough teeth, if you don't have enough power behind it, maybe you need to have amendment from wherever you got your laws from. Because I must tell you, we're going to be exercising this commission from this point on out. And I'm sure people are going to get tired of seeing the sunshine. We're going to have to walk around with sunglasses on after a while, because that's the only way we're going to get some clear, what we call, what I'm trying to say is community reform. Now, I'm going to be out there in the community trying to get community reform. I'm going to be lobbying just like Obama is for the health reform. But here in San Francisco, we need community reform all over in the city. And we're going to be bringing you cases in which we go hope. And now we have that tool of video. Oh, my God. I got footage of violations. So if we're using that one, I think that was a good thing that you had, Mr. Johnson, because this is the technical age of the tweeter, the twatter, but we have the video. Thank you very much.
Thank you. Additional public comment.
Yes, good afternoon. Peter Warfield, Library Users Association. First of all, I'm glad to hear that one of the members has said that it seems that there is a problem at the library. And I'm glad that another member noticed that after 4 meetings on this matter alone, the library has not appeared. I'm also glad that the chair recognizes that your own procedures say that attendance is mandatory on both parties in a complaint. And while that may be slightly different from the law specifically requiring attendance at an issue that's concerned with documents, nonetheless, that is your procedures, and it doesn't seem to me that it would be so terrible. In fact, I think it would be appropriate for the departments to follow your procedures as you expect complainants to follow them. A little bit of history for some unfortunately new members. I wish that you would ask your own task force to look into its own files and do your own research on what the history is of the library. The library is a wholesale violator of sunshine and has repeatedly, over time and most recently, violated. I alone have filed more than a dozen complaints since approximately 2002. I've won the majority of them. And in many cases, the library did not appear, as you will notice today when you follow up on one of my complaints, where the library hasn't appeared at a prior Compliance and Amendments Committee hearing on this subject and is again apparently not planning to appear either. I think in general, I would urge the strongest possible action, including a specific complaint by the task force itself against the library for not appearing at meetings where it's required to by sunshine. For example, in my case, which is coming up, where it does involve a document denial. Those are clear violations of the law, and that's one approach you might take. Another approach is that you have broad powers.
Please continue. I'm listening.
Thank you. I'd appreciate your full attention since I only have 3 minutes and not to read notes while I'm talking. This body has the authority under 67.30 to bring to the Board of Supervisors in a general way whatever it thinks is important to note with regard to sunshine matters. And I again think that the library, if you think there's a problem, and I think there is a great problem, I think it would be most appropriate as a separate matter from the complaints to gather them together and to advise the supervisors of the nature of the problem just as you see it. Thank you.
Thank you. Additional public comment? Seeing none, the matter is back with the task force. Can we have a roll call on the substitute motion, which is a motion to send back to the full task force for referral to the Ethics Commission on the basis of the willful failure as official misconduct, given the actions of the President of the Library Commission?
On that motion, Member Chu?
No.
Member Chu, no. Member Johnson?
Aye.
Member Johnson, aye. Member Nee?
Aye.
Member Nee, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Craven Green?
Aye.
Member Craven Green, aye. Madam Chair, there are 4 ayes and 1 noes.
Then this will be presented to the full task force. I thank you for appearing. Please call item number 7.
Item number 7 is hearing on the status of the September 22nd, 2009 Order of Determination of Rita O'Flynn against the Mayor's Office on Housing.
Thank you. Mr. O'Flynn, if you're here, you have 5 minutes to present to us the status of compliance or to raise any issues with respect to the order of determination that was issued that you would like.
Good evening. I'm just here to get some response from the Mayor's Office of Housing as to the progress that they've made as far as complying with the order of determination. I or my wife have not heard any progress towards complying with the Sunshine Ordinance Task Force letter of determination. So at this point, I would like to turn it over to Mr. Shoemaker to give this committee an update.
Thank you. Is there anyone to present facts and evidence on behalf of the complainant? Seeing none, Mr. Shoemaker, can you respond, please? And you have 5 minutes.
First of all, thank you. I appreciate you taking me out of order for childcare reasons, and I apologize to folks that have been waiting. I appreciate it. So, very briefly, we did get the order. We continue to believe that we have supplied all of the emails in question. However, I think given the order that we've received, we are prepared to go forward and replicate what we believe we've already turned over in terms of all the emails from the time period in question that the O'Flynns have requested. We will do that, as we've done in the past on a rolling basis. If the O'Flynns, I think in the past what I've asked of Ms. O'Flynn is that if she is aware of any particular set of dates or topics or things along those lines that she knows of, we can quickly try and find within the, I don't know the exact number of emails that we'll have to reproduce again, but we will reproduce them. From my perspective, it's really a situation of us having turned over a group of emails but failed to document on our side exactly what we turned over. I realize that there's a difference of opinion about that, and I'm not interested in arguing about it as much as just kind of putting this all going forward so that we can go ahead and provide them whatever it is that they're looking for. I don't have the exact number of emails. I've got a staff person assigned to do it. We will provide the emails from the time period in question, and if the O'Flynns are aware of a specific email or a batch of emails or dates that they're particularly focused on, we'll try and prioritize that in the process.
Thank you. The matter is with the, are there any other parties who are here on behalf of the city? Seeing none, the matter is with the task force. Mr. Shoemaker, I just had a follow-up. I wasn't 100% clear. You're prepared to replicate the production of what was produced in the past. My understanding is that emails have been deleted from Ms. Melgar Iton's email.
Sorry, go ahead.
And the order of termination was very specific because the proof that was presented dealt only with emails from Ms. Melgar Iton's email box. So please tell me specifically what you're doing to recover those particular emails.
Well, I think there's multiple versions of this narrative, I guess is the best way to put it. And I'll let Mr. O'Flynn correct me where he feels it's different. I think the one issue is, are there emails that have actually been deleted? We've been in consultation with DTIS. We feel like we can provide them with copies of all emails from that period. So
just to clarify, so you're going to get DTIS to restore her email box from those periods and search for the emails that should have been produced?
I don't believe that DTIS's perspective is that there are a bunch of deleted emails from that time period. So I think there's just a difference of opinion about what it is that is actually happening on this front. What I understand from the DTIS folks is they're able to give us a snapshot of that mailbox.
Okay.
We'll provide it. We are going to be providing all emails. I believe from my standpoint, I think there's actually a fundamental miscommunication that happened at the outset of this, because Ms. Melgar Iton is in fact on maternity leave, or was on maternity leave. So there was sort of a misrepresentation of the facts that occurred during the process. Frankly, I don't think it matters at this stage. The important thing is they feel like they don't have the information. We're going to provide it. I think the other issue that had been raised was whether or not there were emails that had been removed from the files. Again, we believe we have a complete copy of all the emails that relate to this. They are not typically part of what is considered a project file. So, for whatever it's worth, I actually don't agree with the factual representation, but I wasn't able to be here at the full commission. But to my earlier point, we're going to provide it, and that's what we'll do.
Okay, so just to confirm so that it's clear on the record that you will work with DTIS to get a snapshot of Ms. Melgar Iton's emails during the time frame covered by the request, and you will search for emails that deal with the subject matters as requested by the O'Flynn's, and you will produce those
We've
emails.
already worked with DTIS to get that information, and we're going to provide it to the O'Flynn's.
Okay, all right. Just so we're clear on that. And what's the time frame for that?
You know, my understanding is it's actually a fairly lengthy process because actually each email has to come up. It's not as simple as sort of scanning your current inbox, so it's actually a fairly laborious process, and that's the reason why I had suggested that if the O'Flynn's have a particular date or set of topics in mind, we'll prioritize within the process. I've got a administrative person in my office who's going to be working on that. I don't have an exact time frame, but they'll be working on it immediately.
And they will produce them on a rolling basis to the extent they find them?
Correct. And if we could get more specificity from the task force, that would be, I think, a boon to the public, because then we don't have to reproduce the entire file since we believe we've produced many of these emails already.
Thank you. I don't have any further questions, but if Mr. O'Flynn in his rebuttal would like to provide some of the guidance to the mayor's office, but we're not ready for that yet. Other people may have questions. Member 2?
It seems from our order of determination, if he wants to be specific, and you can tell me if I'm wrong, we should be looking for all email from Ms. Melgar Iton's mailbox from February 2007. That's what.
That's not quite correct. There was evidence that an email from Ms. Melgar Iton's mailbox existed in February 2007, and the allegation was that it was not produced because it had been deleted from Ms. Melgar Iton's email box. That's one example. This time frame, maybe, I believe, goes back further, substantially before 2007. I believe the request was all emails regarding 1672, 1674 Great Highway, and the time period is broader.
Okay, well, maybe we can work with Mr. O'Flynn and give him a number of months just to get this process started, to start out with, just to deliver something. Because I want to see this deliver something. Because we know there's something there. I'm not sure if the Mayor's Office of Housing I know you believe there's nothing there, but we're pretty certain there's something there. I mean, at the very least, I want to find this one email from February 2007 that she did not produce, because it's got to be there.
As I said, if I can address, I'm happy to focus on any email or any batch of emails that anyone directs us to do. I mean, I think, there's nothing in particular that we're worried about providing. There's no issue in that regard. So,
yeah, we don't get into the issues either. We just get into where the documents are.
But just so you understand, we've provided literally hundreds of pages of documents already. So it's not as if this is us stonewalling the O'Flynn's or this group. It's really a case of them believing that there are certain emails that are missing, us not having proof that that's not true. We've been able to unprove a negative, I guess, is the best way to put it. And so now we're going to replicate the file again so that we can demonstrate that we don't have anything that they don't have.
Any other comments? Mr. O'Flynn, you have 3 minutes to provide a response or raise any other issues that are relevant to the order of determination.
Thank you. I appreciate that the Mayor's Office of Housing feels like they've been forthcoming with providing us with information, and in fact, they have provided us with a great amount of information. However, I don't believe Mr. Shoemaker can speak for every single member of the Mayor's Office or every single employee of the Mayor's Office of Housing. He has no way of knowing whether or not an individual deleted an email, and neither does the Department of Information of Technology. So the only way that we can really track this down is to get the source records back restored from the Department of Information of Technology. What may be helpful is if we could obtain dates that the Department of Technology has taken snapshots of emails. And from that list of dates, we can then narrow down and prioritize the dates that we'd like to have restored. So I think moving forward, that would be the best way to approach this, to get us the information that we're looking for in the most expeditious manner.
Thank you.
Thank you.
The matter is with the task.
But before I go, if the Mayor Office of Housing could work with the Department of Information Technology and at least provide us with that list of snapshot dates within the next week or so, that would be very helpful. And the time period of the emails that we're searching for begins in December of 2004. Thank you.
Thank you. The matter is with the task force. Member Nee?
I think at this point, probably the best course is for us to continue this to next month.
I think we're probably in agreement. I appreciate hearing from the mayor's office that they're working with DTIS, and if Mr. Shoemaker could make sure that the O'Flynn's get the information on the snapshot dates that DTIS has, it sounds like they will be able to prioritize at least the time frames. Is that something you'd be able to do, Mr. Shoemaker?
You know, I'm not prepared to talk about whether or not that's exactly the format that DTIS will work on with us. They've provided us with what they believe to be of all of those emails from that time period. I'm working off that information. I don't have any reason to believe that we need to, go through the process that is being described by Mr. O'Flynn. We're going to provide the emails that DTIS have provided to us. I don't believe we have any other obligation under Sunshine other than to provide those. I think we've gone to where we're supposed to go. I don't know what he's talking about in terms of restoring source documentation. I'm not an IT expert. What I have done is we've worked with DTIS to get to a place where we believe we can provide the emails from Ms. Melgar's file, and that's what we're prepared to do.
Right. But I think, as we understood from DTIS, the procedure by which they restore the emails is they have to boot up basically a snapshot of an individual's, and this is just Ms. Melgar Iton's email box, on a particular date. And those snapshots will change, and the files will have to be re-reviewed for other subsequent dates because emails are deleted in the interim or new emails come in.
Just to be honest with you, Ms. Craven, I don't believe that any of that is covered in our record retention policy. That you need to retain all emails related to a particular project. That's not the nature of our record retention policy. It's not the mayor's office record retention policy. So
certainly. But my point is that's how, I think you're missing the point. DTIS has testified to us that's how they would go about restoring the mayor's office of housing emails for an individual. They can only do so by date. And then they have to be compared. Different dates have got to be compared because emails come in or are deleted between those two dates. That's all I'm suggesting. I'm not suggesting anything about how the mayor's office has to retain email. I'm suggesting something about how there's been testimony as to how they're restored.
I understand, but I don't think our obligation under Sunshine is to restore people's entire email records. It's to provide the records that we're required to provide under Sunshine, right?
Correct, but our order of determination was that emails on the evidence provided, which is all that we had, was that it appeared that emails were improperly deleted under the mayor's office record retention policy, and that therefore we ordered the mayor's office to restore her emails from the time periods covered by the request and to produce responsive records. So that's the order of determination, and based on your prior testimony, it sounds like that's what you're doing.
To be honest with you, all I know is that I believe I have a copy of the emails from the time period in question, and that I'm prepared to reproduce those emails. I don't have information about exactly how the Department of Technology goes about this process. I don't know anything about restoring stuff that wasn't accommodated under our records retention policy. I reviewed it. I reviewed it before I came here. I've reviewed it 4 or 5 times in the time period that this particular case has been working its way through the system. And I get that there's a sense that somehow something has happened that violates our record retention policy, but I'm not trying to be flip. I just honestly can't figure out what it is that is evidence of that problem. But with that said, we've gone the route of saying we will provide all of the records that DTIS provides us for this process.
Right. I guess the question I have then is, what did you ask for DTIS to provide you? Because you had to ask them to provide you something. So what did you request they provide?
I wasn't the person who made the request, but if you'd like, I'll come back and get it. But what I understand is that we are providing all emails from Ms. Melgar Iton's file.
All right. Well, then it sounds like, I hope that we're on the same page. I'm not trying to be combative.
Certainly. I'm really not.
Certainly, I understand. And what we're trying to do here is you asked for a way of Mr. Flynn to help you prioritize, and that's what he suggested he would do, is he would look at the different dates and be able to let you know which date periods are the ones that are a priority. So we're trying to work together here.
I understand, but Mr. Flynn actually didn't give you any prioritized dates. He said from December 2004, which is when his project started. That's 5 years of emails. That's not prioritization. That's I want everything for the last 5
but that's
years.
not what he requested.
But
he said the request itself, which is what you'll have to comply with, goes back to December 2004. He was just stating that in response to a question from Member Chu about how far back these records go.
Right.
That's separate and apart, I believe, from his offer to help you prioritize based on dates. He didn't say the priority is December 2004 through today. That's not what he said.
I must have misunderstood.
It was let me know the dates of the snapshots that DTIS has provided, which based on prior testimonies we understand how they recover. And I will say, for example, the period between April and May 2007 is a priority. Please look at those first. So that, I believe, is what he's offering to do. And if that would be of assistance to you, then I would encourage you both to do that.
Thank you. I think what would be of greater assistance to me would be if he would tell me the dates for which he actually is looking for the email, the date of the email, if he knows of something like that. It sounds like February 2007 is the time period.
No.
I don't have the snapshots from DTIS, Ms. Craven. I'm not trying to be combative. I just don't have that. I don't even know that that's the process they go through.
Okay. I understand that. And I believe part of the problem here is that if the allegation that they've made is correct, they don't have the emails. They recall seeing various emails about certain subject matters. Those subject matters they claim were not produced, and DTIS, the Mayor's Office of Housing did not have evidence to say what was or wasn't produced. The separate issue is that there was a February 2007 email. This is one of many that they claim, but this is one that they had proof of that came from one individual at the Mayor's Office of Housing's web email. It was not produced allegedly from Ms. Melgar Eitan. So there is that's the reason for the February 2007 date. I'm not sure that's a priority. What I would say at this point perhaps is, Mr. O'Flynn, if there are date ranges that you know are a priority, please provide them to Mr. Shoemaker. If he can produce those on a rolling basis and make those a priority, that's great, but otherwise all emails from the periods of the request that are covered will have to be produced. Further comments by members of this committee? We'll take public comment on this matter.
Excuse me, point of clarification here. You guys are dealing with item number 7 right now?
That is correct.
But I hear you have me down as item number 7 on this piece of paper. I'm item number 7. Clearly, it says that. And
which piece of paper are you looking at, sir? On my agenda, item number 7 is hearing on status of September 22nd, 2009.
Does that say Randall Evans at item 7, sir?
This is a copy of our draft agenda, sir, not the final. I apologize, the final is in the binder.
Okay, so that means that you are not on, what number are you actually on right now?
We're on number 7. We took it out of order as I announced at the beginning of the meeting. We will address yours in order after we return.
May I just point out to you, ma'am, why I'm here? I have an emergency. I have the pastor here with me. My fiance is on dialysis at the dialysis clinic, and they want to take her to the emergency room. And I'm wondering if that's a fact. I'm her caretaker. So I don't see the people here that's supposed to deal with me in person. I'm asking if you could be so kind to let my item come up next.
I asked
This is
for...
just an emergency. I just found out 10 minutes ago.
All right. Well, we will do our best. I believe we're going to be taking the Arts Commission issue next.
Okay.
So
thank you.
we will do that. We admitted that's what we were going to do at the prior request. So
I have 2
let's finish this item first. Is there additional public comment on this item? A public comment on this item, please.
My public comment is just on the item being moved up without at least asking if there were any objections. I'm the primary care provider for 2 small children also. I mean, no one's time is any more valuable than anyone else's. And the last time I was at a meeting when an order or request was made to change the order, there was at least asking the other people who are on the agenda if they objected. So I'm just noting for the record that it would have been nice for that to happen.
Thank you. Public comment on the item number 7, which is the hearing on the status of the September 22nd order of termination, Ms. O'Flynn against the Mayor's Office of Housing. Seeing none, this is back with the task force. I believe we're going to continue this until the next meeting. So continued. And I appreciate the parties, and I encourage them to work together to resolve this. We had a request to hear item number 9, which is the complaint against the African American Art and Cultural Complex, out of order. And I indicated I would do so because that request was made at the beginning of the meeting. Please call item number 9.
Item number 9 is hearing on the status of the September 22nd, 2009 order of determination of Randall Evans against the African American Art and Cultural Complex.
Mr. Evans, you have 5 minutes to please update us on what you know of the compliance with the order of determination.
Sure. And I really would hope that we can be clear on something I got to stipulate here. I have my own attorney I pay $200 an hour for, and it's very clear that anything that has to do with a restraining order be brought up at this time would be actually just a slander. Bottom line here is that, number one, when the Culture Center was served, I have a witness here that Ace Washington took the paperwork to Mrs. London, handed it to her. At no time was I in contact with her. At no time was any so-called, which right now is called a restraining order whatsoever, was the problem or the case. Secondly, the San Francisco African American Unfinished Agenda Corporation has a body and also has a secretary, which is Reverend Daniel Solberg. That's the person that they would have had to have communicated with if, in fact, they were cooperating with the type of information we asked for. Most importantly, to this date, they very arrogantly sent us some information since that time. None of the information that we asked for did they send. Most importantly, in closing here, I want you to understand that, first of all, let me go over what they sent and what we asked for. We asked for copies of all their minutes from 708 to 709. They sent us a copy of 2 meetings, 2 sets of minutes. Secondly, we asked for the financial statement of their budget, okay, which meant incomes, expenses, balance sheets, and financial positions. They sent us one budget statement of a tax return. We asked for a copy of their vendors from 2008 to 2009. They sent us none. We asked for a copy of all their employees. They sent us none. We asked for copies of their lease agreements. They sent us a partial copy of their lease and agreement with the Cultural Center, but they also was renting and leasing from the Fillmore Center, and they sent us none. So they choose and pick what they want to give us and arrogantly don't give us anything. In return, they want to come up here and talk about a situation that occurred in the community, whether it was a restraining order or not. That is not the case here. That did not stop them from doing what the Sunshine Act requires them to do. And most importantly, even if that was the reason, I am clearly stating here today that I have witnesses and people here of the San Francisco African American Unfinished Agenda Corporation is a viable organization. It's got people on it, and none of those folks allowed me to be the contact person. But they're not respecting it. And today you'll hear again, I guess, their explanation why. We're here at your mercy asking you to please understand that the African American Cultural Center is right there in our community. They have programs, they have opportunities, and they have reasons that we as a people should be involved with that center. But instead, you have one commissioner that's a commissioner of the San Francisco Redevelopment Agency arrogantly pushing her power around, sending attorneys, trying to throw out restraining orders, making false accusations, when all we simply are trying to do is use the transparency to do some things in our community to move forward. And that's why we're here today. Thank you.
Thank you. Is anyone here to present facts and evidence in support of the complainant?
Yes, my name is Ace Washington, and I'm here in supporting, and let me make it perfectly clear, of the complainant for information. As you may or not know, I'm from the Western Addition, the Fillmore, in which we call it the Fill No More. And we have reasons to say the Fill No More because of the redevelopment agency coming through 50 years of urban renewal, which we know, Negro removal. So let me put that aside and say why I'm here supporting Mr. Randall Evans in the Sunshine Act, because that is the only tool that we have, and I have, in our community to have to find out what's going on in our community. As you may or not know, here come the city and county now that redevelopment is going. Here they come, swamping on our community. There's a meeting right now that I got to leave to go to the cultural center. They're having the city and county is at the cultural center right now talking about a 5-year plan on monies they're going to get from the federal government. But it's housed at a place where they don't even have the respect to come down to city and county and the government to come answer questions. That right there, I'm appalled again. Now, city government has to change. I know I'm trying to do it at the community level, and once I get that together, maybe we'll come over here to Silly Hall and try to change things there. Okay, anyway, I'm just making a point, Randall. Okay, please let me do that. So my point of the matter is, number one, we're here telling you it's an arrogant situation of the African American Cultural Center, and whoever's on their board and their president ought to be held responsible. Now, I know the Arts Commission here is one of their founders, their funders, and from my understanding, they're the property owners there. Well, we want to find out what's going on. We hear rumors that that property is going to be taken away by big developers on down the line. So anyway, we're here saying to y'all, I served London. I'm sorry. That's what I was here. I was going to visit London that day, and I said, well, I'll take the paper up to her because you can't do it. I handed it to her in her hand in front of her staff. Now, if she's wise enough and clever enough and powerful enough to use loopholes to do something that an ordinary development supposed to come there, well, then something is terribly wrong here. Now, the Arts Commission, you're opening up the gates, so we want to find out what y'all doing. If we can't find out for them, maybe we'll go to higher heights. But anyway, I just want to say that it's nothing personal against what we're doing here. We're just going by the law with the tools we have to do it. And it's unfortunate that it's in the Fillmore.
Thank you. The representative from the city, please, or from the Arts Commission. You have 5 minutes to respond.
Thank you. Good afternoon, Commissioners. I'm Jill Manton. I'm the Director of Programs for the San Francisco Arts Commission. I'm Judy Nemzoff's supervisor. Judy Nemzoff could not attend the meeting because she had a pre-scheduled vacation. She's in the Berkshires right now and hopefully enjoying better weather than we are. I believe that we have, I have a file copy if you would like. It's a substantial package of information. It has been reviewed by our city attorney, Aideen Vera, and we believe that we have replied and responded to every request made by the complainant. It includes, I have to put my glasses on, a copy of the African American and Cultural Center's most recent budget, a copy of its most recent tax return, copies of minutes, and I believe that the reason that there may have been so few minutes included is that the African American Cultural Complex was under construction for quite a while and only recently reopened its programs to the public this summer. So perhaps that was the reason why there are so few meetings scheduled. The tenant organization has been very cooperative to the Arts Commission and compliant in providing all of the materials that we've requested. The documents were delivered to the complainant, Randall Evans, by professional messenger service on October 8th. Apparently, Mr. Evans was not home at the time, and there was a note or some indication that the documents could be left at the door. So we do have a tracking number from the professional messenger service. I also would like to say that I have been informed, I haven't been involved in this matter previously, but I had been informed that Ms. London Breed did not attend personally because there was a restraining order issued, and in reviewing all of the files this weekend, because I was just given the files Friday afternoon, I found a copy of the restraining order, and it is signed by both the attorney for Mr. Evans.
That's the irrelevant.
Mr. Evans, please. It's not your turn. It's not your turn to speak.
I asked you to Tab, we're not slandering me. My attorney.
Mr. Evans, you'll have your chance to rebut. You'll have your chance to rebut. Mr. Evans, you'll have your chance to rebut. Please continue, ma'am.
Okay, and it was also signed by Commissioner Frank Drago of the Superior Court. Now, I didn't bring a copy of it, but I'd be happy to provide a copy or after I make one, or if Mr. Rustum could return a copy to me, I'd be happy to give you the only copy I have.
I believe Mr. Rustum has a copy.
Okay. So I believe that the Cultural Center has responded to the requirements of Administrative Code Section 12L, and if there are further questions, I'd be happy to answer them.
Thank you. The matter is with the task force for deliberation.
I have a question for Mr. Evans. Do these documents meet your needs?
No, not at all. I just pointed out to you, first of all, she didn't deliver it to my home. 'Cause my home is not the address. It's an office. Okay? So let's clear that up. 950 McAllister.
I'm just asking whether these
I'm
specific
telling you,
documents, regardless of how they've been given to you.
First of all, I'm telling you no. But I explained to you at the beginning of my meeting what they gave me and what they did not give me. Can you give me the document? What she's talking about compared to what we asked for is totally different. And here's the secretary, because like she said, even if there is or not a restraining order, I'm not the one communicating. Reverend Dan Solberg is. So can he answer the questions that you're asking?
That'd be great.
I'm Dan Solberg. I'm the secretary of the San Francisco African American Unfinished Agenda Corporation. The request that was made under its letterhead included copies of all minutes, and we received only 2 copies. I'm not sure if that represents only 2 meetings by the African American Cultural Center or not. That needs to be somewhat clarified. There was one in December and one in March. Now that includes only 2 months out of the 12 that were requested. I think it's a fairly limited picture of the operations of that board. I think that needs to be examined.
Okay.
The financial statements that were asked for were income versus expenses, balance sheets, and financial position. Mm-hmm. And we received only a budget and tax returns. It does not give a full and complex and complete picture of the finances of that institution. I think we deserve more than that, particularly since our request was specific. We also specifically asked for all the vendors, a list of vendors that are associated with that institution from 2008 through current date on 2009. We received nothing. No vendors, no list, no addressing of that issue at all. We also asked for employees with regard to both part-time, full-time, and per diem, and received no list, no mention whatsoever of any of those. I think we deserve a bit more, seeing that this is an institution that is maintained by the city through the Arts Commission, that we as the public deserve and are certainly have a legitimate right to seeing where that money goes. Finally, we received the lease rental agreement between the city and the African American Cultural Center for their property on Fulton Street. It is a matter of fact that that facility underwent renovation, and that their operations, the African American Cultural Center operations, were transferred or were relocated to a facility that is owned and operated by the Fillmore Center on Turk Street. We have clearly that's been eliminated and removed from public view. and I think that's an item that we certainly deserve to see as well. Again, this is city money that is enabling this institution to do its business, and we as the public certainly deserve to understand that.
Right. So you understand that they are not going to produce documents that they don't have. For example, the financial documents that you were discussing, they may be documents they create, they may not be documents they create.
That may be the case. I can't imagine that an institution that runs at $500,000 a year does not have adequate physical records that represent its life in a little more detail than simply a tax return or a sort of a generic budget.
Right, and the profit and loss.
That's right.
There's a profit and loss statement in here also. Right. Okay. But you understand that if the document doesn't exist, they're not going to create it for you.
Sure.
So that could be the case. But what we should get is a response saying that document doesn't exist.
That's correct.
Which is, lets you know.
That's correct.
So why don't we talk to no, I'm asking questions right now.
One final item that I again need to raise as a matter of personal and professional response. The issue of whether there was a protection order or not has no bearing on this matter whatsoever, and it should be clearly struck from any consideration in this circle.
I think we understand it, and if you'll see from our transcripts from our last discussion on this, nobody ever asked any questions about it.
Well,
so it's not something that's coming up. It's not something that's coming up in the past.
I also find it terribly uncomfortable that it should be raised as a point of argument. It clearly provides a potentially slanderous arrangement, and I think that's simply out of place.
This is part of this hearing is to answer specific questions. Mr. Evans will have 3 minutes to provide additional commentary after this portion has been concluded. But right now, it's only to respond to specific questions from members. May I speak to the representative from the Arts Commission, please?
Yes.
Can you confirm for us the number of meetings that this body has held between July 2008 through June 2009? Because only 2 minutes have been produced.
I cannot confirm at this point because I don't have that information.
Can you commit to me that you will find out that information in the next few days and that you will provide that information to the task force and the task force will forward it to Mr. Evans?
Absolutely.
Right,
and I'd like to get the correct mailing address so it's not delivered inappropriately to his office instead of his home.
All right. Well, I think the best way of doing this is that you provide it to Mr. Rustum and Mr. Rustum will then forward it to Mr. Evans and the secretary of the organization. With respect to the, let me back up here. I think it's important for the complainant to understand that under 12L, which is the provision of the administrative code that governs this situation, only certain types of documents have to be produced. Mm-hmm. Not all documents held by this nonprofit have to be produced under the law. And the types of documents that have to be produced are spelled out in 12L Section A, which we can provide. But it basically only covers the nonprofit organization's most recent budget as provided to the city. The most recent filed state and federal tax returns, except to extents those are privileged. 3, any financial audits of such organization performed by or for the city. 12L provides that additional financial information other than described above may be provided, but it shall be voluntary, not compulsory. So the only thing we have the power to force the arts complex to produce are the budget, the tax returns, and financial audits. That's the only power the law gives us.
Okay.
Unless this is a public agency, and it is not. It is a nonprofit operating under 12L. So, do you, my point here is that the Arts Commission themselves may have additional documents regarding the complex. And to the extent the Arts Commission has documents regarding the complex, those should be produced. So, Arts Commission, I want to know, do you have a copy of the Fillmore lease that was discussed that hadn't been provided that the complex has entered into?
I can't answer that at this point because I am newly appointed in my position and I'm not as familiar with the Community Arts and Education program to that level of detail. And as I said, this matter was referred to me Friday afternoon, and I boned up on the documents this weekend.
Okay, I understand that. Will you be able to provide to this body within the next few days an answer as to whether or not you have a copy of the Fillmore lease, you as the public agency?
Yes,
Thank you.
absolutely.
I would also like you to check your records, the Arts Commission records, to review whether there are other budget or tax return documents regarding the complex, or excuse me, it's the center, that you have in your possession. Will you do that?
Yes, I will, along with the checking about the minutes as well.
So you'll check about the minutes, you'll check to see whether the Arts Commission has a copy of the Fillmore lease, and you'll check to see if the Arts Commission has additional budgetary and tax return information that has not yet been produced.
Yes, ma'am, I will.
Thank you. I don't have any further questions, but I think it's important to note that our powers are limited as to what we can require the nonprofit to produce. It is simply the matter of the state of the law. I wish we could require them to produce more, but we cannot. So I believe that what has been produced is the minimum. The complex could produce more if they wanted, but we cannot force them to. A court of law could not force them to. So I'm not sure there is anything else to be done on this complaint. I'm interested in finding out what the Arts Commission has in their terms of their records, and we're going to get those answers.
Absolutely.
And so my belief here is that we've done all that we can do. If it appears that the Arts Commission has additional documents, those will be produced, but I'm not sure there's anything else that we can do with respect to information on this complaint. Other members? Member Johnson?
Are we limited? Are we limited with nonprofits about employment records?
Yes, those aren't covered.
Okay.
They are not required to be produced under 12L. Our hands are tied. At this point, seeing there's no other debate by the members up here, I'll invite Mr. Evans to have 3 minutes. Actually, I apologize. It goes first to the city. If you have anything you would like to respond and anything additional you would like to add, you do not need to, but you have 3 minutes to do so.
No, I will just make certain to provide the documents as soon as possible to Mr. Rustum. And just lastly, the only reason I mentioned the restraining order was because there was a comment made earlier about Ms. London Breed not attending in person, and I was told that that was the reason why she wouldn't be here in person, so that I had no intention to slander any individual.
Thank you. Mr. Evans, you now have 3 minutes to provide us any additional information.
First of all, can you give me a definition, because I'm very clearly legally what 12L means. What do you mean by it? Okay, would you put the whole thing in order, because you're not seeing the whole package?
It's spelled out in the administrative code,
right,
sir.
but that's providing if they're up under a certain amount of so-called dollars. So what's the dollar amount that you get for the nonprofit?
12L applies to nonprofits who receive over $250,000 in city funds.
Okay, so do they or do they not?
They do.
Okay, do you have that clearly in front of you? Because obviously you're telling her something that you should be telling me, but I'm hearing you, but I beg to differ with you. I believe that under 12L, which they are not qualified to be up under because of the dollar signs, that you seem and I seem to have different numbers. So what numbers do you have in front of you? Because you seem to think, for some reason, that everything that we have asked for, you clearly have shut the door down and says that they only could do so much. Now, I beg to differ with you, and then if that's the case, could you give it to me specifically in writing how you are coming to your conclusions so I can take it to my attorney? Can you do that? You.
I will, if you have questions, I will address them.
I have, no, I'm talking about on 12L. You just sat up here and said on record that your hands are tied and that for the information that I have asked for, simply what they've given me, you seem to think that your body should all agree that they have done a good effort of giving the community what they want and that your hands are tied. So what does that mean? Because that's what I'm supposed to take back to everybody at these meetings that we're attending, that are you the chairperson here?
At this task force, yes. At
Okay,
this
what is your
commission.
name?
It's Erica Craven Green.
So Erica Craven is actually saying that this particular body's hands are tied and that you believe that you guys are satisfied that they have gave their best effort of giving us information. Now remember, the last time that they were here, you guys, somebody from your body specifically told them, don't send nobody up here that's not qualified and fully informed on what's going on. Now you've asked her, oh, that's okay, we're not going to enforce that this time around because it's on record. And here they did the same thing again, and you're being nonchalant about it, and she acts like she just got it Friday, but you guys told them, the last lady that was here, don't send nobody up here that's fully informed. I don't hear no language of that whatsoever. I'm here, my fiance's in the hospital on an emergency call, and you guys are just saying, oh, by the way, it's okay. You think you can get it to me in a couple of days? Fine. Then tell the public that our hands are tied and that's it. Is that fair? I mean, I'm looking right at y'all now, okay? I'm looking at you because I heard somebody up here tell them not to do this. And then she said she just got this information Friday. Come on now, Friday. I've been dealing with this for almost 6 months to years. I'm born and raised in that community. And that information is we're just entitled to it just like anything else. Lives are dying. People are getting killed right there at the culture center. You know, they got a studio there that young black folks can use, and they got opportunities there that young black folks could be involved in. But you're letting a nonchalant situation. You don't walk and live out there. And quite frankly speaking, let me just get clear here, okay, real clear. I have the power and the ability, and I'm highly educated enough to be articulate enough to get back out in that black community and let folks know that what you're saying today, that London Breed and the people at the Culture Center don't have the right, don't have to worry because of, what you call it again? What do you call that? The note she used when her hands are tied. What do you call that? Yeah, what provision? On the number L. So all of us, that's what you're saying. Your hands are tied, they've done the best they've done. There's no reason for us to be here then. We just should come back and fill the room, bring the press, and show that we don't have no repercussions and there's no route we can take. You're not even trying to tell these folks how disrespectful they're being about the word restraining order or not. It bears nothing whatsoever. It has nothing to do with it. And frankly speaking, they don't have the right paper. I don't care who signed what. I know what the judge told us. I know I had 31 people in that courtroom that day, and London Breed had one person. And the judge made it very clear to her where I can go and where I cannot go, what I can do and what I cannot do. And yet and still, all you guys have copies of something. I've never put one foot in the penitentiary. I've been working hard all my life. I got 3 children. I got a daughter that just got a full scholarship. She's going to be a doctor. I have another daughter that's a hybrid patrolman. I got a son that was shot in the head twice, and I'm born and raised in that community. It's the first time I had this kind of dealings with the police and everything, and as being an activist, all I hear about is restraining order, restraining order, and restraining order. That's slandering me. And I think it holds you guys wide open for letting this whole community know this is what y'all going to do, and this is how you're going to act when it comes to us. Don't take the law into our own hands. Bring it to the people in charge. Here's a lady sits up here, the one with the blonde hair. I'm sorry, I don't know your name, but you sit there. Do you guys truly understand that they can't give you what they don't have? Do you truly understand out there in that black community that people are dying right there, right in front of that culture center? Do you understand that? And do you understand that me, as a person that's out there involved, do you understand that we are taking our time to come up here? They get paid for being in there?
Thank you, Mr.
Do you understand how frustrated and unhappy I am right now? Do you understand that? Do you know I've reached my limits to trying to come to y'all and get your help? The very least you can do is make these people respect what we're asking for.
Thank you, Mr. Evans. Your time is over. Thank you.
Do you understand that?
Thank you, Mr. Evans. Please be seated. Please be seated, Mr. Evans. Your time is up.
Because frankly speaking, whether you make them give up the information or not, do you understand it really don't matter?
Mr. Evans, your time is up. Please be seated.
Out there, do you understand that what you're doing don't matter? Do you understand that if I tell you my fiance is in the hospital
Mr. Evans,
near death, and you don't respect that, do you understand it don't matter? Do you think that what I'm really asking you really means that much? That it matters? Let's say you give me everything I
Mr.
want right
Evans,
now. Would it mean
We're
anything?
going to have to take a break. If you please do not sit down.
As far as
allow
I'm
us to
concerned, you can
continue.
take the information, send it back to her. Okay?
We're going to thank you, Mr. Evans. The matter is back with the task force for motion and deliberation. The party in complaint has 3 minutes, and he had the 3 minutes and more. No further comment here. Is there public comment on this matter? Yes. I'm afraid a party to the complaint cannot give public comment. Seeing,
Peter Warfield, the matter before you is not one with which I'm familiar, but I do think that you should look closely at something that the complainant did mention, and which I think has been a problem, may be a problem here, but certainly has been a problem at other times with matters before this task force, and that is the sending by departments and agencies to this body of people who are said not to be really knowledgeable about the matters before you. I think in general, without making a judgment on the particulars of this case, sending somebody who is not fully familiar to your body really undercuts justice and your ability to render justice in particular cases. And again, I don't know the particulars of this case, but I think it's important that you ensure, through whatever means necessary, including writing letters, putting pressure, or even making a complaint yourselves, that you ensure that bodies have people who are fully qualified and fully knowledgeable coming before you, so that your time and the public's time is not wasted with unnecessary follow-ups and questions that can't be answered, essentially throwing a blanket of ignorance from one side on the issue. I particularly appreciate the active questioning by the chair in this matter to try and get some facts and get some information. I think that's very worthwhile and valuable and commendable. And it's unfortunate that in some cases the response was as unknowing as it seemed to be. Again, I don't know the particulars here, but I think that is something that the task force, on an ongoing basis, as well as in this case, should keep very strongly in mind. Thank you.
Thank you. Is there additional public comment on this matter? Seeing none, it is back with the task force. Member Washburn.
I have a couple of thoughts, not necessarily related to each other, but paying attention to the public comments. First of all, in the order, it's the matter of the restraining order, and I agree with one of the members of the public that this has no bearing on the case, and to have this spelled out in our records is doing a disservice to the complainant. I know that there's language in the order of determination about the restraining order. So it's seen the light of day, but I'm wondering if we could, at this point, amend that to, the order of determination near the bottom, there's mention of the restraining order. And I know I wasn't here for the task force meeting. I didn't know anything about it. So when I was reading this for the first time, that caught me up, and I was wondering why it was there. Another thought I have is it seems to me that the Arts Commission has stated that they're going to turn over everything that they can. I'm wondering if we should have adequate follow-up with them to make sure that this has happened. Another thought too is even though our body can't, in this case, force a nonprofit organization, one that's funded by the city to turn over things like lists of employees. Could we perhaps urge them to do so and make a good faith effort to get this information, even though they're not required by law? Couldn't we urge them to consider giving this information? So those are just some thoughts I had in listening to our discussions and the members' comments.
Additional comments?
Just while we're at it, from a housekeeping standpoint, this order of determination failed. So why is it called an order of determination? Everything's written like it passed until you look very, very, very closely at it and you go, oh, wait, this actually failed.
Where there's our practice has been where there's, including when you were chair, is when there is a motion that has been made and that motion fails, is that we issue an order of determination. There's an order of determination. That order of determination could be no violation. Member Johnson?
I just I'm in agreement with Member Williams' insights. Washburn, sorry. Insights in the fact that there are things that are not required by law, but in good faith effort, if there is a demand by the people, especially a large number of people, for information in good faith, can it be offered? And what that does for an organization.
I'm happy to write a letter to both the Arts Commission and the African American Art and Cultural Center strongly suggesting that they produce this information to the extent they have it as a good faith effort to the community to disclose this information. That's the most we can do. And whether they choose to comply with it or not is really up to them. But I'm happy to. I believe if they want to operate and produce more information, they should. Mm-hmm. And the members of the community should have. I believe 12L should be stronger and should require more information be disclosed, but it doesn't. Right. So I'm happy to write a letter encouraging them to voluntarily comply and produce this information. Member Washburn?
Perhaps you could say it. Think of the strongest statement possible, like, we strongly recommend that you produce this. We feel that this information will benefit the community, and I don't know, set some context for this. This isn't purely a matter of the records. It has to do with the community that's struggling with some more, basic and serious issues. So I think something to reflect that.
Member Nee?
On the matter of relevance of the restraining order, it's not relevant perhaps to the question of whether information was provided, but it is relevant to the question of the path, if you will, for providing that information. The information had been requested of Ms. London Breed, and because of the restraining order, it had to go through Ms. Nemzoff. So, this is explanatory, and it is not in any way meant to cast any aspersions on anybody.
Right, and we did include that it was allegedly issued because there hadn't been proof provided to the task force members that it even existed or who it covered. So it says allegedly issued, and that's purposely why it reads that way. But I agree with Chair Nee, it's not relevant to anything about the determination here. It's relevant only to explain why Ms. Nemzoff appeared as opposed to the director of the center. So. All right, seeing no other comment from the members, the chair will write that letter encouraging the center to produce this, strongly recommending that the center produce this information, and we'll also follow up with the commission to find out answers to the questions about documents that the commission has, because any documents that the commission has regarding the center are public records, and all of them have to be produced. It may be that the Arts Commission has additional documents regarding the center, Those are public records, which should be produced. So we will follow up with that as well. And any documents that are produced, any confirmations about the number of meetings that have happened, will be provided by Mr. Rustum to Mr. Evans and or to the representatives of the organization who filed the complaint. Thank you very much for appearing. Seeing as it's after 5 p.m., this is the point where, pursuant to our agenda, we take general public comment for issues not on our agenda. If there is general public comment.
I'm item number 3, and I haven't been called yet.
We take general public comment out of order. As soon as this is concluded, we will go to item number 3, sir. I apologize. We took 2 items out of order, and general public comment pursuant to our regulations has to come the first item after 5 p.m.
Well, as a general part of the public, it's painfully obvious that you can look in this audience and for item number 8, they're not here. Okay? I have an emergency at the hospital, at the dialysis clinic with my fiance. Painfully obvious that you haven't took that in consideration, but I must tell you, I came here the last time and Elliot Hutch wasn't here. I think it's his job to get them, and I think he'll tell you that he has not conferred with anybody at Elliot Hutch. So it's not that I'm walking away from this situation, it's that I got to go and they're not here. Now unless an act of God takes place, I don't think they're going to show up in the next 10 minutes. So that makes me not have, do this matter just go away? I'm telling you I have an emergency, they're not here. You see that, right? No one from Elliot Hutch is here. So you got me, I can't wait any longer. Her pastor's here, she's very ill. You want me to bring you documentations back from there? I'll do that. But he'll tell you that no one responded from Elliot Hutch. They're not coming. I don't know what you do from this point. I'm not trying to be disrespectful. I respect you guys, and I'm here like I'm ordered to be, but they're not. So do I lose my chance of getting at them because I have to leave?
The matter will be heard, and I'm afraid we've made so many agenda changes, we have to proceed. Perhaps one of your representatives could speak to this issue, and we'll let you know what happened.
Can Mr. Washington?
Yes, he can.
Okay.
He can certainly do that, sir.
I don't mean to be disrespectful, ma'am, by taking up more time. I appreciate you guys. I'm just trying to let you know that if we bring everybody from that community down here, they don't understand this procedure at all. Some of them will probably go to jail from here. Thank you.
Thank you. General public comment for items not on the agenda?
I just wanted to say I'm just a little surprised, but I'm not mad at y'all because obviously you mentioned your hands are tied. So obviously, me as a reporter, I'm going to have to look into the matters, and I'm going to definitely investigate the Arts Commission, what's going on here. It is just unreasonable that, and I hate to pull out my race card, but African Americans, whenever we come, and even though we're trying to get information from African American, it's just the power structure here in the city. It's the Willie Brown clique, and you got the Newsom clique, and they're all fighting against each other. And that's what this whole situation is about. We're trying to bring some clarity to our community, the African American community, because right now there's clusters of people that call themselves looking out for our interests. But I call those people special interest groups. I'm not going to call them sellouts. But if I say special interest groups, you know what I mean. And we got plenty of those in our community. And once the news get out and we connect the dots and you find out who the players, you're going to say, damn, I see why these people came down here, because the Western Addition is tied up in a knot and we can't get away from it until this information is revealed. So yours truly, Ace Washington, is going to follow up on this and bring it to this community and to this city. Because without a doubt, we need community reform. We need it in our community. That's the only way we're going to get justice for our kids. Because the people that have been calling themselves leaders for the last 20, 30 years, take a track record and find out what have we accomplished for our youngsters that's going to come behind us. Thank you.
Thank you. Additional public comment on items not on the agenda?
Yes. Thank you. Peter Warfield, Library Users Association. I thought I heard something that was quite startling about the last case as a general matter, and I guess I wanted to follow up. I understood the chair here to say that in the case of an order of determination that fails, it's followed up on at compliance and amendments, even if the order of determination does not pass. And that certainly is not, that's what I thought I heard, and that's as an explanation as to why a 4-4 vote on the previous item that was taken up was here in front of this body. So I'd be very happy to hear an explanation. Certainly that has not been my experience. With respect to what some of the folks here talked about regarding the history of problems or non-problems, I think it would be useful if the task force would schedule some meetings, as I have suggested in the past, in general, for the users of Sunshine, whether they have come with complaints to you or not, whether they have filed complaints that were ultimately not heard, whether they have filed complaints that were heard and won or didn't win. I think it would be very beneficial for everybody to have specifically invitational invitations to folks like that, and a subject or even a special meeting to take up in depth how Sunshine is working for folks in the real world, and for that matter, how the Sunshine Task Force is working for folks in the real world. Certainly you must know from bits and pieces that complaints are typically only the tip of the iceberg. When I was at the Library Commission meeting at which the Sue Cawthon incident occurred, someone came up to me, and this is not about the item on the agenda, somebody came up to me, it's not about the complaint, somebody came up to me and said to me, who had not been to commission meetings before, Peter, is it always like this? Knowing that I'm a very regular attendee for many years. And I said to this person, no, it's not quite as loud, but the underlying contempt for the public is always just there under the surface, I'm sorry to say. So if you want to know about the history of Sunshine in various places, certainly, for example, not only do you have your own records and people like myself, you have, for example, people like James Chafee, who has brought multiple lawsuits against the library, and I think it might be instructive to do specific departments, or as I suggested, generally how it has been working for folks. Thanks.
Thank you. Additional general public comment on items not on this agenda?
Yeah, I just rise to be helpful because I've got to leave, but I spoke with Howard Smith, the executive director of LEL Hutch. I'm not involved with them at all, and he said he'd never been served, so your staff might want to follow up on that. That's why they aren't here.
We will address that on the item. Thank you.
Okay, I'm sorry, but I've got to leave, so I wanted you to know that before I left.
Thank you. Seeing no further general public comment, please move on to item 3.
Item 3 is the hearing on the status of the August 25, 2009 order of determination of Kenneth Kinnard against the Human Rights Commission.
Thank you. Mr. Kinnard, Kinnard, is that the way you pronounce it?
Yes, I just want to know whether or not the Human Rights Commission has turned over the documents to Mr. Rustum. I understand that they were going to do that.
The document I presented the complainant was the email I received late this afternoon.
And just for the record and those in the audience, the email was from Melinda Canio saying there will be no one present to represent the HRC today for today's hearing. The information that Mr. Kinnard requested is now available and will be delivered to him this week.
Oh, okay. Well, then that should I should look over the material and then find out. She said they would be delivered this week. I can pick them up, or
it says will be delivered to him this week. I'm not sure what that means for method of delivery.
Okay.
But what I would recommend at this juncture is that you contact Ms. Canios and talk about what's the best method of getting them to you the most quickly.
Okay.
And that after you've had a chance to review those documents, if they do not represent, if you believe that there's other documents that have been withheld or not produced, or you believe that they're not in compliance with our order of determination, which was to secure the documents and produce them, then please let Mr. Rustum know.
Okay.
And we may continue this matter and have it on the next month's hearing.
Okay.
But only if there's outstanding issues like the documents have not all been produced. So once you review the documents, let us know if you want us to reschedule it for the next month's meeting if all the documents haven't been produced. If you're satisfied, then we won't hear it.
Okay.
Okay.
All right, then, thank you.
Thank you very much. We'll take public comment on this item. Seeing none, the item is closed. Please call item number 4.
Item 4 is the hearing on the status of the August 25, 2009 order of determination of Anne Marie Mabbitt against the Department of Recreation and Park.
Ms. Mabbitt, you have 5 minutes.
I guess I just want to ask first, thank you for your time today. If everyone on the task force today received the 3 exhibits that I submitted last week in regards to this.
I believe there are 3 exhibits in our packet.
Right.
So which should be there.
Okay. So I just wanted to make sure that you received them and that you hopefully had a chance to review them. Exhibit number 1 was a forward of an email I recently received from Ms. Gong, the custodian of record for the Rec and Park Department, noting a number of copies of documents she had for me to pick up, and then reiterating again that at the end of my prioritized list that was initially submitted in response to the request from the task force at the original complaint hearing, item number 35, Ms. Gong again reiterated that there were no documents responsive. And as I stated at the last compliance hearing, that statement in and of itself is a clear violation of the Sunshine Ordinance. And I would request that the department make an order of determination today that Mr. Ginsburg and any other GMs that were in place during the time that these permits were issued and I requested documentation on these permits are clearly in willful violation, and possibly also subject then to violation of, I believe it's 67.34. The department has been on notice since July that I and other members of the public want to see some kind of record of the documents we're entitled to under, I believe it's 67.21, I'm not sure. And there's nothing. There's never been any record kept. I have the same kind of permit for athletic instruction for compensation on the public athletic fields for summertime since 2001. I've had to submit and walk over to the finance department every week a concessionaire statement that lists out the number of students I have, the gross revenue, etc. And they're telling me, even though fully required to do so under Sunshine Ordinance, they have nothing and never have had anything. So that's one comment I have. Also, on their denial of documents responsive to items 73 through 79, which were at the end of that prioritized list, they initially sent me an email saying they had no documents responsive. I then wrote back pointing out that earlier this summer they had already submitted to me documents that showed that all of these organizations identified in these requests, 73 through 79, had received permits at the not-for-profit rate. And having done so, they would have been required to submit some kind of not-for-profit application process, paperwork, and fee. And I'm still being told there's nothing. And then Ms. Gong sent me a separate email after I pointed this out saying that camps were not required to fill out any not-for-profit paperwork. There is absolutely no mention of that anywhere, and that is completely untrue. Exhibit number 2 is a very serious matter, and this regards public access to review public documents. On at least 4 occasions now, I have contacted Margaret MacArthur ahead of time, even though not required to do so, to tell her I wanted to come in during normal business hours without unreasonable delay and review a number of different agenda item packets for various resolutions passed by the Commission. All of these items, regardless of what year they date back to, are in the vault at McLaren. And now it's been over a month that I've requested some of these, and on at least 4 occasions I've simply been turned away on a public access request. And Ms. Gong, who is supposed to be the custodian of records for the department, does not even understand the difference between a public records disclosure request and a public access request. Exhibit number 3 was my new list that I submitted, a copy of my new list that I submitted to the department on October 5th, after they had informed me numerous times that they had completed their responses to the prior list. Every single item on this new list should have been turned over by the close of business the following day that the department received it. Instead, I get a blanket denial from Ms. Gong and a request for an extension of 14 days on every single item. So if you please bear with me, I'm going to go through these very quickly. Item number 1 is requesting public records documents contained in the personnel file of Dana Ketchum. Dana Ketchum was hired in February of '09. There is no issue as to where these documents are or to what documents I'm interested in, and I've specifically noted that I'm not interested in any personal information. I've received nothing. The second item was a request for 2 receipts that were supposedly issued less than a month ago, and I still don't have them. Item number 3 was a copy of a request for a tennis court permit that was dated January 30th, 2009. So again, this is a request for a document that's less than a year old and should have been submitted online.
Thank you. You'll have opportunity to address any other issues in rebuttal.
Okay.
Thank you. Is there anyone here to present facts and evidence on behalf of the complainant? Seeing none, the department.
Good evening, members of the committee. My name is Olive Gong, custodian of records for Recreation Park. Just wanted to give a little background. The department is trying to continue to work with Anna in regards to getting records to her. Just to let you know that in the last month, in September, that we have given her hundreds and hundreds of copies of both hard copies and email copies. You know, just for instance, just the hard copies alone, September 4th, she picked up 315 hard copies. September 16th, she picked up 116 copies. On September 29th, she picked up 414 hard copies. So we are trying to give her documents in response to her requests. We were working on the priority list. We were focused on working off the priority list that she had given us August 28th in response to the hearing on August 25th, where the committee asked her to make a list and for the department to respond to it, to work on it. So that's what we were doing. And during this time, since the last hearing and today, Ms. Butt has continued to give us more requests, both in email and also coming in person. And we have mainly tried to focus on this, bringing her these documents on this list, which I have just told you. We've given her hundreds of documents over the last month. She did come in asking Margaret for documents, and Margaret did say, that she could not provide them at that time, that, they need to be compiled, first of all. They're in different places. Some of her requests she was asking back to 1993. They're in different parts. We can't just let them go through all our files. Plus, it would take more than 15 minutes to search, to find these files. It's not just all in one drawer. Let's see. What else did she ask? Anyways, we are trying to provide Mrs. Mabutt her documents, but we are trying at the same time to, also work on our other work, and we cannot have one person monopolize our entire time answering her requests. So I guess that's my response to Anna.
Thank you. Is there anyone here to present facts and evidence in support of the city? Seeing no one with the task force for questions? Member Johnson.
I have a question for Mrs. Mabutt. It says here that the department had 414 hard copies for you to pick up, and there were 10 cents a copy. Did you pick those up?
Yes, I did.
So you paid...
I pay every time I
Yeah,
pick
you
up the
pay every
documents.
time that you go, even though it's a voluminous request, and it takes up a lot of your time as well.
Yes.
To me, it seems like you have very specific requests, and they haven't been made. Yes or no?
They haven't been met, you mean? Or haven't
Yes.
been? No, they have not been met.
Okay, that's my only question.
Yeah, no. And these are very short. I mean, in this particular instance, what we're dealing with today, these
Thank you.
are not voluminous or difficult to load.
I just have a question for Ms. Gong. Item 35 of Ms. Mabutt's request is a copy of each and every transaction between each and every permittee that received a permit for a summer athletic field permit for $25 an hour for up to 25 kids to conduct for-profit summer camp program activities on the public athletic fields of San Francisco, and any citizen of San Francisco regarding enrollment and or payment for any summer 2009 camps programs that they attended and or paid for. Your response was there are no documents responsive.
Yeah, I personally don't keep these documents, so I need to ask staff, whether or not they have documents. And so when I get a request from Anna or,
Who did you ask?
So I asked Dana Ketchum from our Permits and Reservations Division, and she said there are no documents. So,
And do you have any reason to believe that there are documents that are responsive to this request?
No.
Personally? No.
No.
All right, Ms. Mabutt? What specific evidence do you have that documents responsive to that request exist? And please use the microphone.
Well, it's simply the Sunshine Ordinance requests that the department keep some record of this from the permittees, and they're not. Otherwise, they'd have documents that are responsive.
Right, so your point is you expect them to be there, but they haven't been produced.
Right.
Right, but you have to understand that generally speaking, the failure of a department to create documents is not something within our purview.
Well, they're not creating these documents. They're just keeping, it would just be, these permittees that I'm concerned about would just be required to submit some kind of record,
right, but,
like I do.
But if they're not, if they're not being required to, whether permissibly or impermissibly,
yes,
we don't have the authority to say you're in violation of Sunshine because you haven't you haven't received those documents. We can't hold someone in violation for failure to either require documents to be submitted or failure to create documents. If documents exist that are responsive, that are in the possession of the city, and they haven't been turned over, that's what we have jurisdiction over.
So what is failure of any department head under this provision shall be a violation of this ordinance? What does that speak to then?
That speaks to failure to produce responsive documents or to hold open meetings. If the documents don't exist, there's nothing we can do.
Okay, so what's the whole point of 67.297C if they just don't have to do it then?
It's just, I'm sorry if it's not an acceptable answer, but I think you've gotten your answer. Your answer is they don't exist. They don't have them. And whether you want to bring that to the attention of the commission to say that you believe that they should be receiving these documents or creating these documents, that's your recourse. Basically, 67.297 is you must keep accurate records. 67C unfortunately deals with, I outside entity, so it doesn't apply here. It
Well,
deals
it
with
does.
it. It doesn't. In any contract, agreement, or permit between the city and any outside entity that authorizes that entity to demand any funds or fees. So if I'm the Park and Rec and I have a contract with, Mike's Maintenance to, I have a contract with Herb's Ponies to run a pony rental in Golden Gate Stables. I then will require Herb's Ponies to keep, because they're running it on behalf of the city, to keep records. But that's only if there's a contract to provide that service with the city. Here, there is not.
But there is. I mean, there's 29 permits that were issued.
A permit is not a contract, ma'am. It's a different issue.
But it says permit in here too, though.
A contract, agreement, or permit between, there's nothing that's authorizing the permittee to collect funds to perform, maybe I'm missing it, but I don't think that applies. And the bottom line is, I mean, maybe someone would disagree with me, but I don't think that applies in the situation. To me, that applies in the situation where the city is paying someone to perform a government service, and then that entity is then performing the government service and charging people, right? So that entity shall maintain records regarding the performance of its duties, right? Here, what you're doing is you have the government entity and a permittee. It's just, I'm not explaining it correctly. Maybe our deputy city attorney can explain it better, but it doesn't seem to me to be applicable from what I understand in this situation. So,
I mean, it's just that the city's entered into these permits between themselves and a number of different organizations specifically for the purpose of conducting athletic instruction for compensation. Their customers and children are being charged.
Right, but what...
And I mean,
that would apply to any permittee, and I don't think that's what that would apply to any permittee of the city. That would apply to a building. It would apply to a number of issues. I don't think that applies here. I think the intent is something different, but again, maybe the DCA is a different analysis.
Well, just from reading it here, I would think that there might be some application. I'm not familiar with the facts that are being alleged in this complaint because I didn't review it previously. But for instance, the way I read this provision, if Rec and Park, for instance, issued a permit to the Outside Lands Festival, and the Outside Lands Festival held a concert at the Golden Gate Park and charged members of the public admission fees, then I think that they should have, under this provision, an accurate record of that transaction and that permit.
That's exactly how I kind of read the intent of it. Because I don't know if I have to save this comment for later, but I mean, essentially what has happened over the course of the last 2 years is starting really with the passing of Ordinance 070815, is the Park and Rec Department has essentially privatized almost all of the recreation program without any opportunity for public comment. As far as I can tell, for the last 13 years, ever since being required to do so by the city charter, not a single Park and Rec Commission meeting has ever been publicly noticed as required by the charter.
All right, I'm sorry, but then now we're getting a little further afield. All right. Basically, the complaint that we dealt with was you should turn over documents responsive to the requests. That was what the order of determination said. Now, this may or may not be a separate violation, but, and again, it maybe requires more analysis. The DCA thinks it might apply. I'm not sure. I'd have to look at it in more depth, look at the legislative history. I just don't know. But the bottom line is, that's a separate violation, right? I mean, this is something that's come to light because they are producing documents or saying they don't have documents to produce. So it's not before us on this order of determination, unfortunately, as is the other two things you complain about. We can encourage the department to comply, but it's not an issue of compliance with the order of determination that's before us. Part of that is that we have to provide due process notice to the department of what's at issue here.
Yes.
And what's at issue here is the compliance with the order of determination, which was produce the documents you have.
Okay.
Okay.
So given
so anyway, so that So I appreciate the comment. It sounds like that's a dispute for another day. With respect, Ms. Gong, I have a question for Ms. Gong again.
Can I just ask one question quick?
No, you'll have a chance to rebut or to provide additional information. Also, the other issue was that for immediate disclosure requests 73 through 79, with original copies of any and all receipts for the fee for the annual application to be approved for not-for-profit or approved public benefit fees for athletic field permits. And the response was no such documents exist. And can you explain how you reached that determination?
Once again, I went back to Dana Ketchum for clarification regarding this because, Anna, asked about it. And she wrote back, she says, for items 73 to 79, and this is, I'm just quoting her, she emailed me back and quote, none of these organizations submitted APBP applications. Camps were not required to do so. So I'm just quoting what she said to me in her email. So
again, so the issue here is that camps were not required to submit these documents.
That's what she said. Yeah,
Therefore, you have no documents to produce.
That's, yeah.
All right. Thank you.
Okay.
I don't have any further questions. I mean, I think what we have here is the department has complied with the order of determination. It took them a while, but that was because there was a number of requests. To the extent they don't have documents that Ms. Mabbutt thinks they should have, that's a separate issue, unfortunately. All that we can do under this order of determination is say you complied or did not comply with producing documents that exist. The fact that they may, in Ms. Mabbutt's view, violated a different provision of the Sunshine Ordinance or violated their own responsibility by not tracking the information or not collecting it is not something that we can deal with today as I see it. I would like to address one comment to the department, which is I appreciate that the department has been producing a number of records, and it's been a burden. There's no doubt about that. It's been a burden. Unfortunately or fortunately, it's a requirement, right? I mean, it's part of every city and county employee's duties, and it's part of the department's duties, and they, I think, have been doing the best they can. However, with respect to review of documents that should be readily available, like agenda packets, that, to me, is something that someone should be able to produce on relatively short notice for inspection, irregardless of the fact that other members of the department are complying with voluminous requests. So I know that's not before us today officially, but I would encourage the department to allow Ms. Mabbutt and others to review documents that are readily accessible, like agenda packet information, without an appointment and by the close of that business day. Clearly, if it is in a vault that's going to require someone 2 hours to go and get, okay, maybe it would make sense to say, we can't pull it today, but we'll pull it tomorrow, or what's convenient for you. Readily available information like an agenda packet from last month, there's really no reason to do that because it should be accessible. But if we're talking about materials from 2 years ago, or depending how the department keeps their information, it may require some time. But my ultimate point is that information should be provided in relatively short order because it should be accessible. Agenda packet information is quintessentially information that should be available for review on a very short time frame. And those are my comments. Other members? Seeing none, Ms. Mabbutt, Ms. Gahn, you have 3 minutes if you choose, though, to respond or provide any additional information. You don't need to, but if you would like to.
Like what I hear what you say about the agenda packets, and just like for packets going back to 93, many years. I mean, I'm just wondering if we could have, some time to do this. What would you think is a okay amount of time that we can do this? I mean, can we have our normal, 10 days?
try to respond to that after the comments. Thank you. Ms. Abbott, you have 3 minutes.
Okay, regarding the public access, I regard that request as totally improper. If I was a member of the press and had been turned away 4 times on a public access request, I think that would be a very serious problem. The fact that I have sunshined them on extensive misconduct is completely irrelevant, as you mentioned. And many of these resolution agenda item packets now I've requested almost a month ago and still don't have them. As I was starting to say, the exhibit number 3 that I had submitted for today, I was getting halfway through that. But these are the new items that I've requested. So I just want to clarify from the task force then. So if the 14 days passes and I don't receive these items, I have to file a new complaint, or what's the appropriate procedure?
We'll address that.
Okay, and then I'm just still trying to find exhibit number 3 now. But the items I had asked for, like I said, one of the items was a receipt, 2 receipts that should be no more than a couple pages long. One of the items also, I can't find my list now. There were 5 items total, and one of the items is the annual reports regarding the City Fields Foundation partnership. By Ordinance 060255, the general manager of the Park and Rec Department was required each year to submit a report regarding the status of that partnership agreement, or MOU. And they were required by the ordinance to submit those reports annually to the clerk. The clerk's office has nothing. So the only place these reports could be is in McLaren Lodge, yards away from Ms. Gong's desk. And again, I still don't have those documents either. Like I said, I reiterate, every single item that I just submitted to them on October 5th, I should already have. There's no reason that any of these documents should have not been turned over by this point. And they all should exist. The 4th one, I believe, was regarding the request for a permit that was issued to Ms. Ketchum's husband, blocking out entire public access to the Mountain Lake tennis courts for, I believe, a 3.5-month period. That permit on his face was a violation of the professed policies of the permits and reservations procedures regarding the issuance of permits. And that permit was issued before Dana Ketchum was even an employee of the Park and Rec Department. So one of those items I've requested is a copy of the request for that permit. And again, that should have been submitted on the online system and would have been auto-responded in seconds, and I still don't have that document either. And as I explained before, it's very disturbing that most of the documents I'm waiting on from someone whose misconduct is at the base of all of this.
Thank you. Matters with the task force for motion and deliberation. I will just attempt to respond to the 2 questions that were raised with respect to Ms. Gong's question about the time frame for pulling packets. The department has to use its best efforts to comply within the time. If it's an IDR, and if we're talking about a packet that is stored next to the desk of someone in chronological fashion, that can be pulled in 5 minutes. If we're talking about a packet that is stored off-site, then clearly it has to be requested for retrieval. That is going to take the amount of time it's going to take pursuant to the department's policies for retrieval of stored records. So I can't be more specific than that. The department needs to use its best efforts to get that information, and readily accessible information stored, near someone's desk should be responded to very promptly. It is appropriate for an IDR. With respect to Ms. Moffitt's question about new issues, unfortunately, yes, they have to be subject to a new complaint. Now, I hope that Ms. Gong sees, I'm sure she does, sees where this is going, and the department will continue to do the best to get you this information, or else there will be a round of complaints. And I hope that you appreciate the department is perhaps doing its best. Perhaps there's something nefarious going on, perhaps there's not. But you need to do what you can do to make the department's job easier to get the documents that are a priority and be clear with them. And if you haven't been satisfied, then you file a new complaint. That's really all we can do, because we can't adjudicate matters that haven't been raised through the complaint process, or else it would be problematic from a due process standpoint. So I understand you two are on different positions, but hopefully in the long run, everyone will see that providing the documents that you can, when they can be provided in the most expeditious manner, is the best for all sides, because it will avoid further complaints and the need for you guys to be here. If there's no other comments by the task force members, we'll take public comments on this item.
Yes, Peter Warfield again. I'm not privy to the details of this, but I have a couple of observations. First of all, I get real nervous when I hear numbers of pages being cited as in some fashion representing effort provided. My favorite example, thank you for the nod, my favorite example was when I asked for a very simple thing, namely the Sunshine Ordinance Task Force's meeting agenda packet for a particular date. Well, it was more than 600 pages. So if somebody were to cite as an example of tremendous effort that they provided me with a copy of a Sunshine Ordinance Task Force meeting, which in fact I had at the time a standing request for, if they were to show that, gee, we gave them 614 pages on this particular day, without even saying what it was in front of a body like this, I would get nervous too. It was one single agenda packet. The reason I remember it so clearly is because it was the subject of a complaint that I filed with the clerk's office for overcharging at 10 cents a page, when in fact legally only 1 cent a page was allowable. Second, the disappearance of, or the non-existence of documents has, I think, perplexed at times this body in one form or another, and certainly the public. Section 67.29-7, correspondence and records shall be maintained. Section A says, the mayor and all department heads shall maintain and preserve in a professional and businesslike manner all documents and correspondence, including but not limited to letters, emails, drafts, memorandum, invoices, reports, and proposals, and shall disclose all such records in accordance with this ordinance. I think you have a very strong obligation to say, yes, such and such kind of a record is an absolutely appropriate thing that should be maintained in a businesslike way, and if it ain't, there's something wrong or something fishy. Furthermore, Section 67.29-6, sources of outside funding, says, no official or employee or agent of the city shall accept, allow to be collected, or direct or influence the spending of any money or any goods or services worth more than $100 in aggregate for the purpose of carrying out or assisting any city function, unless the amount and source of all such funds is disclosed as a public record and made available on the website for the department to which the funds are directed. When the funds are provided or managed by an entity and not an individual, that entity must agree in writing to abide by this ordinance, by which I understand it to mean you ask where'd the money come from and so on and so forth, you're entitled to it. And it goes on with another short sentence. So I think that there is a very strong duty for responsible, reliable, and businesslike professional record keeping, and you, as the interpreters of this ordinance, have the right to say, that ain't professional, or that doesn't sound like professional to me.
Thank you.
Thank you.
Additional public comment on this item? Seeing none, public comment is closed. I don't believe there's anything left to do on compliance with this order of determination, but I would encourage the parties to work together to avoid the necessity of complaints. That may be wishful thinking, but hopefully that will be the result. So thank you very much for coming. Do members wish to take a break, 5-minute break? Yes, let's 5-minute break. Then we will resume.
I said, there you go. Oh, well, I thought he was going to grant your wish.
What? What wish?
She said, I wish I had a snack.
Jerry has a snack. Erica doesn't have a snack. Hey, can I call my grandpa? I have to call my grandpa. I have to pick him up at the airport tomorrow and figure out when he's coming. They won't let us
You're not
either,
allowed
Jerry.
anymore. Right back here, I guess. You can have my drink. Did you hear me when I came in and I was like, the TV was up and I had misinterpreted like from the last meeting
Hey, Grandpa.
that December
How are
1st
you?
is when everything was going to be online. And I was like, I think we're going to be filmed today.
Oh, Grandpa. Come on, Grandpa. Just get that surrender.
Yeah, we were.
It's been very, very much. I think it's me, you, Justin.
I think it's just audio, but it's supposed to be. This is one of the most entertaining ones we've had in a while. But it's going to get more intense over the next year, which is part of that flyer, which is part about getting the people voted this in. So the people are going to really have to be the ones to come in. Like, we don't like, give us more power. We want us to have more power. Depends on what happens. Supervisors. It depends on some of the amendments that we make. Mostly public comment. Going to 3 minutes, not limiting to 1 minute. If you have an important agenda item on you feel like it's going to fill up the courtroom, the room, have people staying outside, and one wants their 3 minutes. Isn't every citizen allowed 3 minutes? That's not what it's about. You're like, that's a big one, isn't it? When the zoo, when a guy got attacked or whoever, tiger incident, the hallways were filled. The hallways were filled with people. Public comment was put down to 1 minute. And everyone's kind of very serious. I've been in there and having, some of them have been real good about just giving someone their 3 minutes, no matter what they said. No matter what they said. They're like, thank you. You know Marlena? Amanda. I met him in a kind of party. He was like, I'm like, I'm Doyle.
They were there when that program was first starting. I think it was like 1 year long.
Did you have the opportunity to join?
Yes,
That's
you know, I never. They did, right? They wouldn't have been eligible. Yes.
Which is very unusual.
I remember one of the same programs. Kids from the program would be singing in Chinese, and very few of them were Chinese.
Yeah.
So.
Well, that's what I feel like, you know, it was arguable whether or not Chinese.
And color in Chinese. I'm like, what color?
No, I hope that. Not sure why I'm paying for that. So, yeah.
Well, Alyssa is married to a Chinese American man, and
Is she the one with the kids? The kid?
no, that's my son. 2-year-old. She's 2 years old.
He's not Spanish, right?
Yeah, well, Christy is half Filipino. But her father, you know, definitely is Filipino.
They asked
so.
me what I knew about it. I told them I'd call it the
She does have darker skin than. I love the darker skin.
Comstock.
You know, Ben was, gosh, I think he was 5th grade maybe, and
I did.
A girlfriend, his first
They were like,
kind of
well,
serious girlfriend.
I guess
And she was from El Salvador. And her sister was having her first communion and invited Ben to go. And he got lost from the family and had to come and take him to the park. Speaking Spanish, they all just gave him lots of food.
Yeah.
But I remember picking him up,
Maybe.
and he goes, Mom, he said,
All right, we're back in session. I believe the next item is item number 5.
Item number 5 is hearing on the status of the August 25, 2009 order of determination of Peter Warfield against the public library.
Before Mr. Warfield begins, Mr. Rustum, did you notify the public library this would be on the agenda?
Yes, Madam Chair, I did.
And did you receive a response?
A response was received from Luis Herrera saying that he will be out of the office and will return on Thursday, October 15th.
Did you notify anyone other than Mr. Herrera about this?
I also notified Sue Blackman.
Okay, and did you hear back from Ms. Blackman?
I did not hear from her.
I would note that there's no one from the library in the audience. Mr. Warfield, you may approach, and you have 5 minutes.
Thank you, Madam Chair. Peter Warfield, Library Users Association. I might note that this was a document denial case, and that in the case of document denials, it says in the Sunshine Ordinance that the department basically is required to attend any hearing, and they are not here. So if you want to count non-appearances, add 1 notch. In this case, I asked for copies of Park Branch renovation plans. I was allowed to review these documents once in March, and then when I requested copies, I was promised copies after a bit of a tussle, some of which might be considered obstructionism. For example, they said they couldn't make copies on 8.5 by 11 sheets of 2 particular pages that I wanted, unable to do so. A library unable to make copies of oversized sheets. Okay. Finally, I agreed, after some negotiation and time spent on this, back and forth, to get the full set in the full size for something like $38. They then sent me a note saying that I believe it was March 10th that they were working on it. On March 11th, they sent me a note saying, no, they weren't going to provide this. You heard most of this, those of you who were present at the hearing, and on an 8-0 vote agreed with the complaint that the library unlawfully withheld 50% construction documents, which is what they said was the latest version. The order of determination according to what I'm reading here in the agenda packet, the task force finds that the agency violated Section 67.21 of the Sunshine Ordinance. The requested documents shall be produced to Mr. Warfield within 5 days of this order of determination in the agency, and the agency shall appear before the Compliance and Amendments Committee on September the 8th, 2009. For those who were not here, they did not come on that date either. Following the order of determination, you got a letter from the library dated September the 4th, in which the library said, and we discussed this at the last Compliance and Amendments Committee, the library will be providing these documents to, I'm reading from paragraph 2 of their September 4th letter, to the task force with a copy sent to Luis Herrera and Peter Warfield. The library will be providing these documents to Mr. Warfield for inspection and or copying. We emphasize, however, that these drawings are a preliminary draft and they are not for construction. And here's the key. It should be noted that disclosure of construction documents that are at a more advanced stage of completion would present a different question. I never heard from the library further than this letter. And when I happened to go to the library administration offices, which include Luis Herrera, the library, the city librarian, and the commission secretary, I believe it was on September the 14th. Then I was told, oh, we have this for you. Well, that's not within the 5 days required, and so that's number one. Number two, they said there was no original plans available. Those, they told me, had been destroyed. Instead, I was given a half-size, 11 by 17, approximately half-size copy of what was said to be a copy that had still been retained by presumably Department of Public Works. There was no documentation to back any of this up as to the destruction, and one of the little games that happens with the library, it seems, as a pattern, which unfortunately is not subject very obviously to complaint, is that when at another meeting on another library matter, I started to chat with somebody from the city's other department that has to do with architectural matters and asked, do you routinely destroy 50% CD documents? Basically, he told me not really, not until the project is completed. Before he could fully finish, the library was right in there saying they had to talk to him on an urgent matter and pull him away from me. So I would ask you to ask the library, where is the evidence that you've requested the original and that you were told that the original was destroyed? I was also told that the library would not provide current plans and made a request for information about the current plans at that time.
Thank you, Mr. Warfield. You'll have additional time. Seeing no one, anyone here to present facts and evidence of support? Seeing no one, Mr. Rustam?
Madam Chair, following your email to me asking whether Mr. Warfield had received his copies and a call I sent in to Sue Blackman, I got a call from her on Thursday saying that she had provided all the copies. And she also said that she wasn't able to reply earlier because she was out sick.
And you specifically asked her if she provided the 50% construction plans?
Yes, I left her a message, and she responded saying yes, she has provided.
Thank you. The matters with the task force? I'm not always going to ask questions, so come on, people. Member Nee?
Well, I have just a kind of a comment. I think the fact that the 5 day compliance was not met seems to me to merit some consideration here. And as a matter of fact, this is why I tried to get this on the agenda at the last full task force meeting, because there was apparently some time sensitivity involved. I think at the very least we should find that there was a failure of compliance on the 5-day window. Whether we want to characterize that as willful violation and send that up to ethics for that reason, that, I guess that remains to be discussed among us. But another thing that Mr. Warfield has said is that what they gave him was really not something that was, and Mr. Warfield will correct me if I'm wrong here, but it seems to me that what he said is that what the library gave him was not what he had wanted, and was really not something he could use to the extent that he could have used the original. So from where I sit, there has not been compliance here. There was not timely. Even if there was compliance, it was not within the 5-day window stipulated on the order of determination.
Member Washburn?
Yeah, I just want some clarification. So it sounds like I'm just wanting to make sure that the materials that Sue Blackman said that had been sent last Thursday were the documents that Mr. Warfield was referring to that were inadequate. I'm just wondering if there's some more responsive documents that have been produced more recently.
Through the chair, the message I left her was, has she provided Mr. Warfield with the documents mentioned in the order of determination?
And that was copies of the 50% construction plan.
But the copies that Mr. Warfield was referring to were those copies, and those copies were not usable. They weren't in the format that he had asked for.
They weren't full-size copies.
Okay.
Architectural plans are architectural plans.
Right.
And it sounds like what they provided were shrunk 8.5 by 11 copies.
That you wouldn't be able to see, pretty much.
Could I?
Member Dean?
Mr. Warfield? You said the copies that you received were basically half size of the original, right?
I believe so. I have not measured with a ruler the originals, but as Ms.
They
Brady
were
Green
noticeably reduced, right?
Absolutely, yes.
Okay. And why could you not? Why were the copies that you received not useful? Why are they not in compliance with what you had asked for?
I did not say that they were not useful.
Okay.
I said they were not what I requested. And the first thing that I requested, and what I always request, is originals. There are times when originals have very light colored stamps or lightly penciled notes. And I'm glad to see the city attorney is nodding. There are times when the originals have colored pencil markings or colored ink markings that speak of some kind of, not a secret code, but just like color copies of things where the colors mean certain things. In some cases, as for example with blue or red, those colored notations may not show up at all in a copy. Sometimes the backsides, or there might be things attached, and so on and so forth. So when I want the copies of the plans as I saw them in the original, I want to see them. I certainly want to be able to read them without getting a microscope. And after that, the copies that had been promised and then withdrawn literally the day before I was to sit at a neighborhood group at a table with the president of the Haight-Ashbury Neighborhood Council and discuss in front of a public meeting what the plans were at Park Branch. And the Jewel Gomez, the president of the Library Commission, and the chief of branches were at the other table. To have that denied to me the very day before that meeting seems to me to speak of some kind of possible motive. But to be able to read those plans, that's not the same thing as getting only a copy and approximately half size, which if you look on the original plans, those are already very tiny when you get to the portions where you want to see specific details. And as an example, One of the most important specific details is this. In a very beautiful open room with uninterrupted open space, 100 feet by 41 feet with a 23-foot ceiling, as Park Branch is now, the plan was to put a closed staff workroom into the middle of that space on the left, adjoining the left wall. And I wanted to know how high are the walls. When I speak to people about a closed workroom in the middle of an open space, my joke these days is it's like 40 porta potties lashed together and stuck into the library and then scooped out and used as a workspace. I want to know how tall that is. I don't want to have to waffle and say, well, it looks like it might be about 9 to 11 feet tall, but and so on and so forth. So the full-size original is important, and a full-size copy is important as well.
And the copy you got was a black and white copy?
Yes.
And what I think I heard you say is that the lack of color actually meant that certain information basically didn't show through. Is that right? Because of the color coding?
I don't know this. I saw the original in March once, and I'm not an architect. I studied it as best I could. And in fact, one of the most striking things about the original was something that was in the margin that wasn't even anything specific to the particularities of the plan. And that was my discovery, that they had completed all of the detailed design and 50% of the construction documents quite some time prior to the very first public meeting that they held in that branch to supposedly solicit public comment. So what I'm saying is originals are important because they may, not guaranteed have, but might have a whole range of information that can be useful in one way or another. And I don't know whether the copy that I received accurately reflected the original because they told me there was no original. By the way, I might add, there was no mention to this task force that the original had disappeared or was no longer available. It seems to me if they knew that the original wasn't any longer available, they should certainly have told the task force.
Not to be accusational in any way, but I do know that there are certain pencils that you can make all kinds of notations over plans, architectural or an art design, that are called non-photo blue copy, that when so there are things that don't show up.
His point, Mr. Warfield's comment here proves the problem I have with holding the agency to a 5-day violation of the 5-day deadline. Did Mr. Warfield want to inspect the originals, which would show these issues, or did he want copies? Okay? We ordered that the documents shall be produced for inspection and produced for copying. We didn't say. And it sounds like Mr. Warfield wanted both. Part of the duty, therefore, is on Mr. Warfield to make it clear to the agency what he wants. If he wants to inspect the originals, he should have informed them. He could have gone down and looked at them. Maybe the department should have provided the copies within 5 days if it was ambiguous. I don't know, but it was ambiguous. And Mr. Warfield proves his own point. Or proves my point that it's ambiguous because he wanted both. And he should be entitled to both. Don't get me wrong, he should be entitled to both. But holding them in violation for failure to produce documents doesn't seem to me to be appropriate when the library said, hey, we're going to either let him inspect them and or copy them. Right? I mean, that seems reasonable. Right? The library says that on the 4th in a letter that is CC'd to Mr. Warfield, and Mr. Warfield, I think, can reasonably be expected as an advocate to say, all right, I want to inspect the originals and I want a copy of the plans. I don't think that's an unreasonable burden to put on the requester when you have an issue of wanting to inspect the originals and get a copy. So I don't think the 5-day violation is something that I would want to pursue. I don't think there's been a violation with our order. I do think that's problematic that Mr. Warfield has not been given copies of the originals and that the originals were at some point destroyed. And first of all, as I understand it, that these copies were on CDs that were shared with various or there was an electronic link to them at some point, I believe, and they were shared with various interest groups, according to a document that Mr. Warfield circulated. In fact, I have it. Please review the Park 50% CD submittal with your staff. Electronic copy of these specs, as well as drawings and comments, will be made available at the following link. L City Library Branch Improvements Project Files, Park Design, Part 50% CD submittal. Is it possible to print that CD on a full-size copy? Would seem to me it probably is. Have they destroyed that link that would allow them to do so? It seems to me that's questionable. So while I don't believe there's been a violation of the 5-day rule, I do think that there's a problem, an ongoing problem, with the production of only these shrunk down copies. And I myself have represented public records requesters seeking architectural plans that have been maintained by the city, and know firsthand that access to full-size copies for inspection and or copying of the full-size copies is in fact required and useful for being able to view issues such as grading or heights or other issues that wouldn't be necessarily represented to scale on a shrunk down copy. So that to me is the bigger issue here. It seems to me if Mr. Warfield stands before us today and says he wants a copy, a full-size copy, then he should get that copy. And so, Mr. Warfield, I'll ask you, do you want a full-size copy? To the extent it may still exist.
I'm not sure that at this moment I want a copy of the 50% CD, because remember what I had asked for originally was plans for Park Branch. And if you will allow me to say...
I understand that. I know where you're going, and
Okay.
Thank you for the response.
Okay.
The order of determination, unfortunately, dealt with, right or wrong, the 50% plans. It did not say the most recent plans. The library said, here are the plans that we have, here are the plans we withheld. I think you're entitled to the 70% plans to the extent they exist. I think you're entitled to the most recent plans, but that's not, in my view, what the order of determination is, unfortunately. So my question was, do you want a full-size copy of the 50% plans, the plans that are, right or wrong, covered by the order of determination? If you're willing to pay for the full-size copies and you want those full-size copies, I think I will move or have a motion to see if we could do something to get you those copies. If you do not want them and you will not pay for them, then I will not.
First of all, I would like copies of that. And I'm very sorry that you started in about my unclarity. I think my request, which is not in this document page, is not in these pages, was very clear. I want to see and have copies. And as far as their letter goes, I think it's very clear what they were suggesting, and that is that they would offer me the inspection of the originals. The library will be providing these documents to Mr. Warfield for inspection and or copying. And I believe that the sensible interpretation of copies is if after 6 months of struggling over this, he wants still the copies of something which may be quite well outdated, then we'll give it to him, but we won't require him to spend $38 on something that's clearly outdated. So I think it's quite clear when I went there, I wanted to see the original, and I was simply handed the copies. And I paid for those copies. I did not argue with them or question it. I was perfectly willing to take full-size copies as I had originally requested in March, and now it was September.
All right, so you are willing to pay for the full-size copies if we can ascertain that they exist?
If we can ask for what? I'm sorry.
If we ascertain that there is a full-size copy available, you are willing to pay for that copy to have
Yes,
the
and
50% plans.
And I share your skepticism, though I want to see the originals.
Yes,
I don't know what they're talking about, and I agree with your skepticism about all those places in which they had the document and now claim it's gone.
I agree. All right. Then, thank you. My instinct here is to, I'm not sure what the best way to doing this is, but I think we need to tell the library that what they produced was insufficient, that Mr. Warfield wants to inspect the original and that he wants a full-size copy of the original documents, or of what, if there's a full-size copy remaining on that link or wherever it is, that they should produce that. And if they claim that they are incapable of producing a full-size copy at this juncture, to explain why that is. So I believe we should, send them that letter, and my instinct would be to continue this, unfortunately, to the Compliance Amendments Committee for the next meeting. I know people may be frustrated with that, but I don't personally feel there was a violation of the 5-day rule because of the inspection and or copying issue. And I'm not sure what a referral would do at this point back to the full task force. I think the best course, what we can do, what was within our power, and hopefully what we can get done, is to get Mr. Warfield the opportunity to inspect the originals in a full-size copy. Any other comments by members? And Mr. Warfield, you have 3 minutes.
I made a request to see the Park Branch Library renovation plans. The library initially showed me a large format, what I consider to be and believe to be an original plan. They then reversed course with respect to the provision of copies which I requested, and also refused to let me see further the original. I don't think there's any question what I requested, and I think it's very specious to say that there was any question whatsoever. The facts of the case in your own letter say complainant Peter Warfield made a request for copies of Park Branch Library renovation plans, was allowed to review documents, and so on and so forth. Whether you want to split hairs about what was intended by your order of determination, I'll leave to you, but I think that the library fully understood what was required, and that is they said they would allow inspection and or copying. They did not allow inspection of any original. They provided no evidence that the originals had disappeared, only their own statement, and you are the ones who are here skeptical of that. Certainly I am. I think that the library should be required, certainly, to show what evidence they have, what efforts they made to get the document, and what evidence they have that it supposedly doesn't exist. I think that the 5 days was certainly not satisfied, as Member Nee said, and I think it's your duty to refer this to higher powers because of the provision in Sunshine. If the custodian under Section E for Edward under 67.21, if the custodian refuses, fails to comply, or incompletely complies with the request described in B above and so on and so forth, and that's when you guys get to hear it, and then the task force shall immediately order the custodian of the public record to comply with the person's request. If the custodian refuses or fails to comply with any such order within 5 days, the Sunshine Task Force shall notify the district attorney or the attorney general, who may take whatever measures she or he deems necessary to ensure compliance, and so on and so forth. I think that's what the law says, and I think that's what's happened, and I think that's what's appropriate. Whether or not you think that that's going to be effective or not, whether you want to send it further, that's fine. But this is what the law says is required, and I think it's certainly what I, as the complainant, deserve. And I think it's very clear. I think the library, by its absence here, is unable to answer a whole bunch of questions that you might want to put to it, including what happened to the documents and so on. So I think that you should follow Member Nee's 5-day, consider about willfulness, including their absence from here, and refer this to higher authorities for enforcement, whether or not you think that's going to be actually effective. Thank you.
Is there a motion?
Madam Chair,
Member Neat?
in light of the chair's offer to pursue this matter with the library, perhaps continuation to the next meeting would be in order.
Seeing Member Washburn.
Well, we seem to have a problem with the library. Somebody said that earlier tonight, and
There's the commission and there's the library.
I know.
There are related and overlaps in staff. But.
Right, yeah. But the library, there are problems with the library. So I'm wondering if we can split the difference here between this recommendation and what Mr. Warfield wants, and that's if there isn't full compliance with what Mr. Warfield wants in the next 5 days from when they received notification that they didn't fully comply as required by our order of determination, then I think we should consider going further with this.
I think that would be hard. I mean, you have to have a vote of the task force, of the committee, to send it back to the full task force. I guess what we could do, and I'm not suggesting that we do this, but you may want to make the motion, is to say, the chair will write the letter as explained, expressing displeasure at the failure to appear, saying that the library themselves said that they would provide copies for inspection, or they would provide the documents for inspection and or copying. We're informed that the documents were not provided for inspection and that they have in fact allegedly been discarded and are no longer available, and that post 5 days, the only thing that has been provided was a 8.5 by 11 copy, which is insufficient for Mr. Warfield's use and review, and that we would like the library to respond to the following. When was the originally deleted? What the date is that the originals were deleted. B, is the library can the library affirm that no full-size copies can be made available, despite the fact that we know that a link was provided that provided access electronically to these documents, which we assume were full-sized. Can the library, in fact, produce the original? And if not, can the library produce a full-size copy from any of the CDs or otherwise online access that it created to share this information, and have them respond to those requests within a time certain, perhaps 5 days, and then
Underlines that you're punctuating here, or capitals.
And then, if the response does not come in within 5 days, this committee recommends that through the chair it be scheduled for a hearing at the full task force's next meeting. I think that's the only way that we're going to be able to get this before the full task force for a finding of compliance and referral that would circumvent the need for another compliance amendments hearing. So I think that's what you want.
Yeah, that makes sense. Thanks for your patience.
I'm not necessarily convinced that's the right way to go, as opposed to having it the compliance and amendments, but I think that's the motion you would like to make. Yes? You would make that motion, Ms. Washburn?
I would.
And is there a second for Ms. Washburn's motion?
I'll second.
Thank you. All right. I believe it's time for public comment. Seeing none, the matter is back with the task force for a vote on Member Washburn's motion, which is long and tedious, but basically is give us this information to show that, give us this information to show that you can't comply, or provide for inspection and copying the documents towards Mr. Warfield within 5 days of this letter, or else this matter will be referred to the full task force and heard on their next agenda. If we don't hear back from you, or we find that if you don't provide the information and you don't provide the copies, it's going to be in the full task force. Roll call, please.
On the motion, Member Chu?
No.
Member Chu, no. Member Johnson?
Aye.
Member Johnson, aye. Member Nee.
Aye.
Member Nee, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Craven Green.
Doesn't really matter. I will say no because I'll say no.
Madam Chair, we have 3 ayes and 2 noes.
The motion passes. I will write that letter, and it will go to the library. I hope to be able to write that letter by the end of Thursday. So it will probably go out on Friday, which should give them sufficient time to comply, and before it has to be scheduled for the full task force. That concludes that matter. Item number 6.
Item number 6 is hearing on the status of the August 25, 2009 order of determination of Peter Warfield against the Board of Appeals.
I believe, Chris, you have something to indicate?
Madam Chair, Cynthia Goldstein emailed me this afternoon and wanted to know whether I had forwarded her letter to the members. I said I had done so, as well as I gave her a link to the website where the Bay letter is on display.
Thank you. And did she indicate that she would not be in attendance?
She did not say so. She didn't mention it.
She didn't indicate either way.
Either way, yeah.
I don't see her in the audience. For the record, Mr. Warfield. You have 5 minutes.
I am frankly not sure what the point is. How many times will this committee give 5 days and 5 more days, and then a month more and 5 more days, and a month more and 5 more days? What is the point? An 8-0 victory? You won't do anything to follow up, even when the law says exactly what is supposed to happen. Let's say I'm rather disappointed. This one is fairly straightforward. The Board of Appeals had at least the professionalism to say what they were going to do, and they were going to defy you. We talked about this at the last Compliance and Amendments Committee. They were clear about their defiance of your order of determination. They said they, on their own, had come up with changes to what they said they were going to provide. Namely, they said they were going to now provide, after the order of determination, they were going to provide addresses, but no other contact information of individuals. The discussion in the order of determination, for which I'm grateful, and the decision is quite clear. And it says, to the extent any information has been withheld from Mr. Warfield, that board, meaning the Board of Appeals, is directed to release the same within 5 days of this order of determination. I'm not sure what letter Mr. Rustam is referring to. I'm not sure what the date is. Nothing has been said. I haven't seen the Luis Herrera letter. I haven't seen any of this material. Neither has it been presented here in the book. Neither have I been told about it prior to the meeting. I don't appreciate stuff being sprung on a member of the public, and your own rules say that material that one party or the other wants in the agenda packet is to be provided a week prior, and that if it comes afterwards, it is not to be considered. And yet I'm hearing all this stuff coming from this department and that department that you're being told even before I have any knowledge of it. In any event, your letter was clear in requesting the Board of Appeals attendance. On the second page of my agenda packet, not numbered, a letter from Erica Craven Green says, this is an issue of ongoing concern, and members of the Compliance and Amendments Committee request your presence at their next meeting on October 13, 2009 to discuss this issue and explain the task force's prior determinations as to the appropriate release or redaction of phone numbers and email addresses. So basically what Ms. Goldstein said she would do in one of her early letters, she did do, and that is she provided a look at not originals but copies with redacted material, and again, there is a problem with that. But in any case, the file also had been jumbled up so that the original sequence in which things were provided was brand new. So it took quite a bit longer time for me to review the material as well as to request particular copies that I wanted. Ultimately, I did request from Ms. Goldstein an electronic copy of the entire file of letters that they had received, pro and con, regarding the appeal of the demolition of Ortega Library. And so basically, even on a petition that was presented to people as a public petition, taking one side or the other on this matter, the Board of Appeals blacked out contact information, and I don't even know what it is. I believe it was phone numbers, but I don't know that for a fact. And so what they provided was not what this order of determination required. And as far as I know, it was timely. They did provide, by contacting me after they sent their letter to you saying what they would provide and what they wouldn't provide based on their own lights. But they did contact me, and again, I appreciate their professionalism in doing so that I knew that I could now go, and they had now done whatever they were going to do to the file, which appeared to be to take out the originals and to replace them with redacted copies, so that I was able actually to look at the file without even having anybody watch. Sitting opposite me at the table, and certainly nobody was making comments as they had at the original inspection. Thank you.
Thank you. Is there anyone here to present facts and evidence on behalf of the complainant? Seeing none, I would note there is no one here to respond for the Board of Appeals. The matters with the committee. Member Nee.
Yes, a question for Mr. Warfield. What was redacted? Now, from the correspondence that I saw, I'm gathering they agreed to provide the correspondence, but with the emails and phone numbers deleted or redacted. Is that correct? What's been redacted here and what they provided?
In general, and I didn't go over it with a fine-toothed comb for a reason. The reason was that on August the 5th, the Board of Appeals denied Inga Horton's appeal of the demolition permit for Ortega Branch, and by the time this was going on, the claw machine was already tearing down Ortega Branch Library. So I hadn't a lot of heart for looking over these materials with a fine-toothed comb. In general, to answer your question, unless they made maybe I can find a case where they made a mistake and unnecessarily redacted, for example, the address of an organization. But basically what they did is they redacted email addresses, phone numbers, basically things other than home addresses of individuals. And for the most part, for example, I believe with Dakamomo and certainly with the architectural heritage letter that they received supporting landmarking of Ortega and the renovation instead of demolition, they gave the full address because it was an organization and not an individual.
So what they withheld were phone numbers and email addresses, is that correct?
Of
individuals.
Presumably of individuals.
Okay, and that's where the order of determination was not met. Is that correct?
Yes.
Okay.
Seeing as no one else is dying to jump in, I will just state what my previous policies on this is that I believe, consistent with our prior orders of determination, that members of the public who are submitting correspondence in a correspondence file of this nature with respect to a project, because I think we have to be specific to the documents requested. there are certain circumstances that would fall in different categories. But I think, for example, if someone signs a petition and they put their phone number on, I might feel differently. But with respect to a correspondence file about a project, the information that we have been told is that for individual letters regarding that project, either pro or con, that the Board of Appeals policy is to redact personal email addresses and phone numbers, that I believe that redaction of the personal phone numbers is appropriate in that circumstance, but redaction of personal emails is not, because of the difference in burdens that I explained before at the prior hearing. So my position would be to find a motion, move to refer this back to the full task force for a finding of willful violation under 6730 and 6730 C and 6734, recommending a referral to the Ethics Commission for further enforcement and investigation based on the failure to comply with the order of determination with respect to redaction of email addresses only.
Do you think there's still room for discussions with them? I mean, your letter, and thank you for doing it, and I don't mean to sound critical of it, but it didn't go into the persuasive arguments for email, and they seem to have been okay with entering into a discussion of these issues, albeit by letters. So maybe there's still some room there to win them over.
My sense is that they're complying with the city attorney's policy, which is that information should be redacted, and I don't believe they will. I mean, I would hope they would, but I don't believe they will comply. But if they wanted to, they could appear at the full task force when this issue of the referral will be addressed. And if they, they could appear and say, we've rethought it and we're going to produce email addresses and our phone numbers, or we're not, we're going to stick to our guns.
I just think we'll get farther convincing some city department to do it than to refer to ethics.
Well, that conversation could take place at the next full task force meeting, because the referral is not automatic. It has to be voted on by the full task force.
Yeah, I know. I just we've already got 10 cases for the next one, plus all the stuff we've added on here. Now we're talking 10 o'clock at night, and no one's going to want to discuss it at 10 o'clock at night. So, unfortunately, the interesting work of the task force tends to never get done because it happens at 10 o'clock at night. So.
Member Nee?
Yes. Has there been a second to the motion?
I don't believe so, but I will formally make the motion.
Okay, I will second.
I'll formally make that motion. And Member D seconds. Sorry.
Okay, and I would add a friendly amendment to add 67.21E for failure to appear at this meeting.
That's acceptable.
They were notified, and they did not say one way or the other whether they would come, and 67.21E makes it quite clear.
That's acceptable to me. If there's no further comment here, I believe, Mr. Warfield, you have 3 minutes to respond.
I think that I would support referring them to whatever authority is mentioned in Section 67.21E. If further letters or discussions, if you think those would be helpful, that's possible. I just want to back up and say that I think one of the unfortunate things about these hearings is that nobody has ever gone into, with them or without them, how this all began. And how it began was that I appeared on the final day when agenda items could be included, letters could be included in the agenda packet, which was July 30th. And I asked to see their file, which they called docket. The very next day, they consulted an attorney, the identity of which they wouldn't tell me orally. That was the subject of a complaint. And they concocted an entirely new set of rules. All of this redaction business and all of this restriction on review was made up literally without documentation the very half day after I showed up there for the first time to look at the file. And I hope that the task force will be able to take up that matter in some way in future. Their absence from being present here, I think, hampers you in finding out some basic information about how this so-called policy was even created. But as I understood it, the director, the executive director, Cynthia Goldstein, was contacted by an attorney, changed the rules completely, and made them what they were when I came in with the complaint. Subsequent to my complaint, there was this change of rules which they told you about and informed you that, well, maybe they were a little strong in those rules. But remember that those rules didn't exist for over a decade, at least, according to members of the staff that I had talked with. So in any case, that's part of the backstory. I don't think it's a pretty one. And I also don't think that the city attorney's role in any of this is pretty when you consider that the ordinance says that the city attorney is not to be advising departments on the keeping away of documents from members of the public. That's another issue that needs to be discussed by this task force when they routinely, and you know that they routinely are advising departments on when and how and what to withhold and redact. In any case, I think that 67.21E, a referral, is appropriate. I think a separate issue with respect to their failure to attend is appropriate, and I hope that that goes forward then to further so-called enforcement action, but what might otherwise be called referrals, which, again, I hope you do without regard to what your interpretation is of how effective it is, because, in fact, it's effective for other purposes, including not only your duty, but your evaluation of what has happened with respect to compliance. Thank you.
Thank you. Any further discussion by the task force members or comment? Member Washburn?
I have nothing.
Public comment on this issue? Seeing none, public comment is closed. Roll call.
On the motion, Member Chu?
No.
Member Chu, no. Member Johnson?
Aye.
Member Johnson, aye. Member Nee?
Aye.
Member Nee, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Craven Green?
Aye.
Member Craven Green, aye. Madam Chair, we have 4 ayes and 1 no.
Thank you. I believe the next item is item number 8.
Item number 8 is hearing on the complaint filed by Randall Evans against the Ella Hill Hutch Community Center for allegedly not providing documents under Chapter 12L.
Thank you. And before we start, I believe Mr. Rustum has provided me an email showing that he notified the following individuals of this complaint being on our agenda. Maria Sue at the DCYF, SFGov at SFGov, Howard at ehhcc.org, and Solberg, SOLBERG, at stpaulus.org. But I see no one in the audience. Before I call the complaint and give the full 5 minutes, I'd like to follow up with Mr. Rustom. I believe at the last hearing, before this task for this committee, we asked you to do some investigation as to whether or not the Ella Hill Hutch Community Center was a qualified 12L program, meaning did it receive over $250,000 in city funds? And if so, who were the city agencies that administered those contracts, to find out who would the city agencies be under 12L that would be responsible for ensuring compliance? Can you please tell us what you found out?
Madam Chair, I went to the City and County of San Francisco Controller's website, looked on their vendors list, and looked for Ella Hill Hutch Community Center, and I found it under the Children, Youth, and Their Families Commission. And the head of that commission is Maria Sue, as whom I addressed in the email. I also sent a copy to Mr. Howard, who is the executive director of the center.
And were you able to ascertain whether or not there were any additional agencies or departments within the city who administered contracts?
In the packet, Madam Chair, I have a list of all the agencies that are involved with the center.
Okay. And did you...
And none of them, except for the Children, Youth, and Their Families, exceeds the 250 limit.
Right, but 12L does not require that one particular department provide $250,000. It provides the city, I believe, provides $250,000. So all of these departments that have provided grant funds for 09-010, Children, Youth, and Their Families, Mayor's Office, I guess those are the only two, would theoretically be responsible for responding. So I guess you didn't contact the mayor's office.
I did not contact the mayor's office.
Did you receive any response from anyone at the Children, Youth, and Their Families?
Madam Chair, no, I did not receive any response.
How did you know to contact Ms. Sue?
I believe it was Miss Teresa Casey from the Shelter Monitoring Committee that she
suggested
that, yes.
And what's Ms. Sue's position?
She's the executive director.
Okay. And you did not hear back from her?
I sent her an email, and this is my follow-up.
Mm-hmm. Okay. All right. So, and I would also note that the information you provided shows that for FY 2009-2010, the Ella Hill Hutch Community Center is scheduled to receive $250,056. So they would qualify under 12L by $56. All right. With that background, I would invite Mr. Washington up, who I believe to speak on behalf of the complainant.
Yes, my name is Ace Washington. I am a longtime community activist in the Western Addition. And on top of that, yes, I have very special interests here at Ella Hill Hutch. I'm a longtime community activist at Ella Hill Hutch. As you may or not know, Ella Hill Hutch has been through turmoil ever since the director, Lefty Gordon, had died. They had a number of executive directors took over. But last year, it was very important. That it's funny that she mentioned about the mayor's office. Where the mayor's office and City Hall came to our community, and in my opinion and others, did a hostile takeover. And I guess it was needed to do that because they were going to close the doors because of misappropriating funds and the way the programs were. As you may know in your records, Ella Hill Hutch at one time received over close to $5 million, then dwindled down in previous year before the hostile takeover. What I mean by the hostile takeover was when the city came and told them you must change your board, your executive director, if you want any more funds. It also found out that it was owned in that property is owned by the Park and Rec. So anyway, what I'm saying here is, number one, the information that we requested, it was very, very important, simply to Mr. Randall Evans and myself, because we are one of the main long-time activists here with LHOH. We were there when the hostel came over, when Dwayne Jones from the mayor's office and Fred Blackwell, Supervisor Ross, they all from City Hall came down abruptly and said that this is going to have to change around or we're going to close the doors. Automatically, the community had rebelled against it because we figured City Hall was coming down to take something that we thought was ours, the LHOH. And now they came up with their own board again. And so the question is, we want to know what's going on there. Who's running things around there? The funding sources. Because I'm going to tell you, I have rumors and thoughts that big developers have plans in the next 3 to 5 years to come close it down and build developments. But that's not why we're here. We're here trying to get information about them now. As you see, they didn't show it last time, and they didn't show this. I went directly to their board of director president and said, man, you guys, wait, we don't know nothing about it. We ain't got to be there. I went to their board executive director, which he said, Mr. Chris said that he sent an email that he must appear. But they said, wait, we're going to go to. So my vision is that they're being told by, it might be the city and counties, the city attorneys, we got loopholes for y'all. Because obviously they're feeling that they're above the law and don't have to be here. Now, I'm appalled that I got to use my time when I'm supposed to be at a very important meeting with the cities coming to the cultural center. Has to be here. But I think it's worth it. But I'm here to see what's next. I mean, do you have the authority to have them come summons, or do you have to pass it on to the board of supervisors, or do you have to go directly to Mr. Gavin? I would suggest you go to Mr. Dwayne Jones. Call Dwayne Jones. He's the #1 African American advisor to the mayor. He's the one that came down and made this transition. I believe if you call Mr. Dwayne Jones, he is responsible from the mayor's office. Call him down. I bet he'll show up. But anyway, I'm here to say I did my duty to come to tell y'all that, #1, community reform is what I'm lobbying for and campaigning. And community reform means to inform our community to make things better. So I do see this is going to be one of my havens here. I might have to bring a lunch and come by here and burn the candles, because you guys are here late at night here. But go ahead, do your thing, and I'm supporting you. But I'm also here to say that we hope that something can be done. And as viewing from the people, I'm not here to ridicule or point the fingers, because people we're talking about happen to be African Americans. But because of the color does not make things to continue on. Because we have to show some kind of credibility, accountability. So I'm hoping and praying that my waiting these long hours will not be in vain. And I do appreciate y'all, because you guys seem like you have a task on your hands that, and you know what, I wouldn't mind in the future be part of this, because I sure would love to be sunshine a lot of people. But you're doing a wonderful job. Thanks a lot.
Thank you. Seeing no one else in the audience to present facts or evidence on behalf of the complainant or on the respondent, the matter is with the task force. I have a suggestion if no one else has. Seeing no one else. This is frustrating, because the part of the problem here is that what we were tasked with finding out is whether or not they're 12L, or given the fact that they run a shelter perhaps on property owned by the city, it's unclear. We don't have that answer. They could also be covered by another provision that would require them to provide more information than just the minimum under 12L. But we don't know that, because we haven't had anyone here from LHOH to answer those questions, or from the departments that provide them the grants. And that's frustrating. Mr. Russum has done his best to inform these people that this is an issue that we're trying to resolve, has not heard. My suggestion would be that I send a letter as chair of this committee, another letter to the executive director of LHOH, to Maria Sue on behalf of the San Francisco Children, Youth, and Their Families, and to Dwayne Jones, if he is still with the mayor's office, explaining the situation, explaining the information that we need, asking them to provide the information, and asking them to take responsibility for providing responsive information at least under 12L in the interim. Because really the issue is, it looks like they're covered by 12L, so the minimum information that 12L requires to be produced should be produced. And then providing us with enough information to determine whether or not they might be more fully covered under the Sunshine Ordinance. That's what I would suggest as the next step and continue this matter. Unfortunately, there's very little we can do if we can't find these answers.
Chair. Mr. Evans, I would also like to add that you are a part of Sunshine. All of the community is, and this is a reciprocal relationship. We're here because of you.
Member Nee? Member Washburn?
You made a motion. Did this have a second?
It probably doesn't need a motion because it's just a letter.
Okay.
But without objection.
Okay.
And we're continuing the matter?
We'll continue the matter, and I will send the letter as explained. Our goal here is to try to get the information as much as is legally required to Mr. Evans, Mr. Washington, and to their group. And that's what we'll try to do. I am personally frustrated that we haven't had a representative from Ella Hill Hutch and others here. But what we can do is just do our best to get that information, and that's the aim of the letter. And I apologize for having to continue this to another meeting. Public comment on this item? Actually seeing none, but Mr. Washington, you have 3 minutes to respond.
I just want to get this clear. So this means that there will just be continued, and you would notify the people that you said you would notify, and we'll have the same episode again in, 3 weeks, 2 weeks?
Well, we will ask these individuals to, A, provide the information required under 12L as soon as possible.
Okay.
And B, to provide additional information to us to clarify whether or not this organization might be required to produce more information. Because if you're 12L, as we discussed, only a minimum of information is required to be produced. They can voluntarily produce extra. But if you're considered a policy body under the ordinance, or basically the equivalent of a government department, then you're required to produce much more, and we have to figure that out. So we'll be asking for information which would answer that question.
Would you be requesting that they show up in person? I mean,
yes, and then we will request that representatives from Ella Hill Hutch show up at the next meeting, as well as a representative from the city department. Do you have a date for that date? Mr. Rustum?
Madam Chair, we are looking at November 10th.
November 10th.
Thank you.
Okay. Well, thanks very much. I appreciate your time and effort. And
again, seeing no public comment. Is there public comment on this item? Because I took it out of order.
Yes. Thank you, Madam Chair. Peter Warfield. The question of whether an organization is a 12L organization or the other that you described seems to also have perplexed individuals and this body. And so I guess I would like to ask, I think it was said that Mr. Rustum checked somewhere or another to see if something or another was on a list. Is there a definition anywhere other than a functional definition within the law? Is there any requirement that a list be posted, for example, of this is or is not a 12L organization, this is another kind of organization, as you described, a policy body? That certainly seems to me something that the task force ought to consider advising on, because over and over again it perplexes people. Does a body get in a given year $250,000 or more from the city or not? If this year it got a little less, $249,000. If next year it gets $260,000, how is anybody supposed to know that? And why is it so difficult? It seems as though that ought to be something that you just go find out very simply either from the organization or from something. After all, the city is paying money. So if the city knows that it's paying money, perhaps the city ought to have a very simple place to list what's what isn't. And I guess I'm still not clear when you said policy body. I'm not understanding a policy body. I thought is a government body. In any case, I would love to hear more about this, but I do think that how you even start to try and figure it out on any of these cases tonight would be helpful for others to hear. And I think you may want to also describe the weaknesses and difficulties in determining it as a prelude to recommending improvements, which would basically be to have some simple way that ordinary folks can figure out what category an organization or a body belongs in. Thanks.
Thank you. Seeing no other comment, this matter shall be handled by letter as I described, and it will be continued to the next meeting. I believe number 10 is the next item on our agenda.
Item number 10 is developing recommendations for the proposed electronic document retention policy of the Sunshine Ordinance Task Force.
Member Nee, do you have an update for us on this?
Nothing new to report. However, I would note that the Committee on Information Technology is to hold a meeting on October 23rd. And unfortunately, I didn't bring with me the time, but it will be at, I believe the address is 1 South Van Ness.
Thank you.
I'll send out an email on it.
Thank you. I believe Member Washburn, you may have volunteered, perhaps somewhat, without, what's the word I'm looking for? Foolishly, perhaps, to help Member Nee on this by investigating if you could discover kind of national protocols or other sort of standards that maybe the GAO or other federal agencies have come up with respect to storage, maintenance, and retrieval of electronic documents. And if maybe that's something that you could work on in the interim.
Yes, I haven't had a chance to do that work yet, but I'm very interested in the issue and plan to do some investigation before the 23rd.
Great, wonderful. Seeing nothing further, the next item.
Next item is the continued discussion on the proposed amendments to the ordinance.
On this one, as I said, due to a time crunch, I have not been able to meet with Chris, but I need to meet with Chris and perhaps Jerry and ascertain a way that we can track the work that we're doing here, which has to be resubmitted to the full task force for approval. I will endeavor to do so before the next meeting. I will also endeavor to submit my final recommendations of things that need to be changed or issues I see that still need to be addressed. Member Nee has done so. I will endeavor to get that so that it's in the packet for discussion at the next full meeting, and encourage other people to do so. And I believe other folks were also going to help me review suggestions, the very detailed suggestions made by
Alan Grossman. And
also Chemo Crossman as to issues that they felt should be addressed that we had not addressed. And would appreciate folks to do that. And if during their own review of the amendments or the review of the comments made by Mr. Grossman, they felt that there was suggestions, concrete suggestions that they would like to make in advance of the next meeting, to have those submitted so that they could be included in the packet and discussed as well. Member Johnson.
If I can have your email, Ms. Washburn, I may have something from Chemo Crossman about record retention and and different models.
Mm-hmm. That's with respect to the prior item, but perhaps relevant for the amendments as well. Member Washburn.
I was out of town for our last meeting, and but took some time in the interim to review the ordinance, with the exception of the very last section. And I have found a lot of, minor typos and things, but I had some more substantive questions. So in what form, or how do I disseminate this? Because right now it's just a bunch of stickies.
It's an excellent question. I think there's two ways of doing that. We can go over them now, today, or perhaps at the next meeting when there's more to discuss on this item and maybe fewer, maybe not, other items on our agenda. And you could just go through them on the record, in open session. The other way of doing that is that you can do what Member Nee did, which takes more time, which is to kind of draft a memo and say, here are the typographical things I've found. Here are the substantive things that I think we need to consider, and do that in the form of a memo, which then would preferably be included in our packet as issues to be discussed at the next meeting.
Our next meeting, or
our next meeting?
The CIC meeting.
The CIC meeting. Because what we're trying to do here is tie up all loose ends, both typographical and substantive, and then return to the full task force with a revised set of amendments that they approve, and that's what we'll then hustle on to bring to Board of Supervisors and members of the community.
Okay.
So whatever you would prefer. I think it's most helpful if you could do it like Member Nee, but you may have too many, and it may just make more, especially if it's just questions like why did we do this and why did we do that. That might be more useful just to discuss at the next meeting, and perhaps depending on the nature of the comments that we have and the suggestions, we may only get through Article 1 or Article 2. Article 1 is very short. But that's what we plan to do, is to get all of our homework done and then march through it to get a final resolution.
I think that I'll take a stab at putting some of this to paper and
that would be
organizing it so that we can go through it efficiently. Yeah.
That would be wonderful.
Okay.
Public comment on this matter. Seeing no one in the seating section, public comment is closed. The next item.
Item number 12 is the administrator's report. The only thing I need to tell you besides the report is starting the 1st of November or the 1st of December, our audio files will be online.
What will be online?
The meeting audio files.
Audio file.
In digital format?
In digital format.
Fantastic. That's great news. Thank you very much. It's overdue, but we understand that there was technical issues with respect to the people who host our website. So we appreciate you following up on that and making it happen. Member comment on the administrator's report? Seeing none, there's no public comment. The item is closed. Next.
Item 14 is announcements, questions, and future agenda items.
Member Johnson?
This is for our attorney. Did you find out whether or not the seal of San Francisco could be used on the flyer? Your stand-in at the EOT said probably, but to get back with you, and that I will bring it back at the full task force meeting.
Yes. Well, there were two related questions. One was whether the city seal could be used, and the answer is yes, because it's an official communication of the task force. And the separate related question was whether personal funds of members could be used to pay for that, and the answer is yes. That's an informal gift of personal funds to the city for a public purpose.
So it's yes, yes.
Yes, yes. That's good.
Yes, yes, yes. Any other future agenda items or announcements? Nope, that is it. I will move to adjourn.
Second.
Who's in second?